Morning.
May I please, Your Lordship? I beg to mention item number 27, Lordship. This matter may be passed over for the day, Lordship. Petitioner, no instruction, Lordship.
Petitioner,
No instruction.
you are on behalf of the petitioner.
Petitioner, Lordship.
27.
27, Lordship.
Who is there? Have you taken consent from the respondent? Have you taken consent from the respondent?
No, Lordship.
Huh?
No.
Have you taken consent from the respondent or not?
No.
You informed them you can't take the respondent by way of a surprise. You can't just mention the matter and go home while the respondent will wait all along. We will see, you be there when the matter is called. This court will see that at that time. Yes, call the list.
May I please? Lordship, may I allow to withdraw this petition, my Lord? Withdraw this petition, my Lord.
Withdraw.
Yes, my Lord.
Heard Mr. K.M. Hassan, Learned Counsel for the petitioner. Also heard Mr. D. Das, Learned APP for the state respondent. Stop. Mr. K.M. Hassan, Learned Counsel for the petitioner, submits that he has received instruction from the petitioner not to press the instant anticipatory bail application. Stop. Accordingly, he seeks withdrawal of the same. Prayer is allowed. This petition stands dismissed on withdrawal.
May I please, Your Lordship?
Yes.
Lordship, here the petitioner who is an unemployed below poverty line, Lordship. They applied for, Lordship, some loan under the Prime Minister's employment.
There was some wakalat number required to be filed in this
Yes,
matter.
Lordship. Because earlier Mr. K. Gogu was, Lordship, I just...
File your fresh wakalat number.
No, Lordship, but because I got the file yesterday only.
So please say that before you go to the merit of the case.
Lordship, I have
Because how can you address this court without filing the necessary power?
I'll contact the client, Lordship. I'll contact Lordship.
When can you file it?
At least 7 days time at least required.
Your name?
A.R. Tahbildar.
Mr.
A.R. Tahbildar.
A.R. Davila, Learned Counsel for the petitioner, submits that he is yet to file the fresh wakalatnama in the matter on behalf of the petitioner. Stop. He seeks for further 7 days time to do the needful. Prayer is not opposed. List this matter after 7 days. Date didyok. List this matter on so and so date.
24th minute.
Upar etu add kori diba niki dorate that in view of the change of counsel, in view of the change of counsel, Mr. So and so has entered appearance on behalf of the petitioner. Semicolon. However, he is yet to file his wakalatnama. Tar pisot time to khuja bili kori.
Obliged, Lordship.
Yes, have you?
My lord, we have not received any instructions. The petitioner is in our contact.
No, but this then, because already on the last occasion, APDCL submitted that the electricity connection has been restored. Yes, Mr. Pathak, what is it? We'll close the petition.
Lordship, yes, he was not in possession of the premises. The petitioner, Lordship.
Petitioner is not in possession. But the in this writ petition, the petitioner sought electric connection, correct? Which has otherwise been restored.
To the person who is in possession.
So basically, you see, restoration has to be to the premises.
To the premises.
Correct, not to the person
Not
per
to-
se.
Lord.
So, to the premises in question, the electricity has already been restored, correct,
Yes,
Mr. Pathak?
It says that another connection in the name of Ritakar Sutradhar, bearing number so and so is being
One
served in
second.
same
You take control of your breath first. You came running.
Lordship,
Sit for a second, let me read this.
Lordship, it's all right now. Lordship, I'm fine now.
some more part I think is there. The petitioner is not residing in this premises presently.
This is what was provided to me. I'll just,
No, check your email. This has come in your mail.
not in my mail, my colleague's email. I'll just,
I will call this matter again. You just give me the complete instructions. I'm disposing of this petition. You wait for some time. Go. Case diary.
May it please, Your Worship. Here, my lord. Initially, my lord, case was registered under section.
Case diary is there, Mr. Das? Please.
My lord, case was registered under section 307 along with some IPC sections, my lord. Subsequently, my lord, 302 has been added, my lord.
2 is added.
Added, my lord. Here, my lord, FIR, Your Lordship will find at page 10, my lord. Page 10, my lord.
Why is this bail application before this court?
Because, my lord, out of same PS, my lord, another accused has approached the honorable court, my lord, and that case was considered by this court, my lord. And now rule is that, my lord, if one case is, my lord, considered...
Yes, where is that order?
That order at page 24, my lord. Page 24, my lord. The name accused, my lord, FIR name accused has approached this honorable court, my lord, and considering the period of detention, my lord, this honorable court has granted bail to the said accused, my lord.
In your case, how many days?
53 days in my case, and this case also, my lord, earlier case, my lord, 53 days, my lord. That Raskeshwar, yeah, my lord. FIR is at page 10, my lord.
His presence is seen. Any specific rule?
He was member of the group which.
But any specific act?
Malad overt act is not.
But otherwise he was present.
Seen that he was also.
Otherwise he was present.
But he was also assaulting. That was seen by the eyewitness.
So then that is the act.
This whether further detention is required. And rather this.
All right then.
Now he has implicated him. This Raskeshwar Bhuiya. Who has been released.
Co-accused. Heard Mr.
K. Borwa, my lord.
K. Borwa, Learned Counsel for the petitioner. Stop. Also heard Mr. D. Das, Learned APP for the state respondent. This is an application under section 439 CRPC for release on regular bail of the accused petitioner, i.e. Sri Sanjeev Hajorika, who is this is bail, right? Who has been arrested on
24/3/2024, my lord.
24 so and so in connection with North Lakhimpur PS case number 9 of 2024 registered under section 341, 294, 325, 307, 34 of IPC and added section 302 of IPC. Stop. The case of the prosecution is that on 16/1/2024 an FIR was lodged alleging inter alia that on 14/1/2024 at around 9 p.m. the elder brother of the informant was returning home on the occasion of Bihu, and when he saw a broken bamboo fence lying in disoriented manner, he accordingly suggested to the youth to remove the fence so that the road becomes clear. Stop. However, the youth became angry and started abusing the elder brother of the informant with filthy languages. Stop. Though he tried to run, later on the FIR named accused persons and others assaulted the elder brother of the informant severely with a stick on his head, resulting in severe injuries. Stop. Accordingly, an FIR was registered. Stop. Mr. K. Borwa, Learned Counsel for the petitioner, submits that the petitioner is not involved in the alleged offence. He also submits that the petitioner has been languishing in the jail for the last 53 days. Stop. Mr. D. Das, learned APP for the state respondent, submits that the case diary reveals that the co-accused, that one of the co-accused has implicated the petitioner in the offence alleged. Stop. Considering the length of detention and the entirety of the matter, this court is of the considered opinion that further detention may not be necessary for the ongoing investigation. Stop. Accordingly, it is provided that the accused petitioner named above shall be released forthwith on bail in connection with the above noted case with a bail bond of rupees 30,000 with a suitable surety of like amount to the satisfaction of the learned
CGM Lakhimpur.
as Chief Judicial Magistrate
Lakhimpur,
subject to the conditions. 1, 2, 3 DD. A similar order at আছে page 24 of. Disposed of.
Obliged, madam.
A return case diary. CD there?
Case is there.
May I plead the lordship? My lord, it is a second bail application, my lord.
Yes.
FIR is page number 12, my lord. Because in earlier,
What is changed?
my lord,
Changed circumstances?
my lord, in the earlier petition, my lord, the actual fact could not be inadvertently placed before the honorable court, my
What
lord.
have been?
Placed before the honorable court, my lord, the
There
petition.
cannot be
my
a
lord.
rehearing.
My lord, the actual fact was that, my lord, that there was a conspiracy regarding the establishment of a government model college in the area, my lord. Even, my lord, in the petitioner's area, my lord, the model college was sanctioned, my lord, and due to the interference of the local MLA, my lord, they tried to shift in the another place, my lord, for which, my lord, the petitioners had approached the, my lord, concerned authority, my lord. They have also moved up to the dispute secretariat, my lord, and ultimately they succeeded, my lord, in retaining the college in their area, my lord. And, my lord, the named accused, my lord, your lordship will find FIR page number 12, my lord. The named accused here in my page number 12.
This is setting the shop of the informant on fire.
Yes, my lord. Jafar Iqbal,
Pathetic, my lord.
436, my lord. Jafar Iqbal, my lord, and this Munna Lashkar.
There is no change of circumstances.
Lord, I will explain, my lord, for a few minutes, my lord. For a
This
few
court
minutes,
is not going to go into the merit of all this. These are matters of trial. You are seeking bail here.
I may be.
After considering the entire materials, bail earlier was rejected.
Right.
Anything, any condition that has
Yes,
changed thereafter, you may indicate.
my lord.
But there cannot be a rehearing of a rejection.
Definitely, my lord. I have annexed, my lord, some documents, my lord. That was not earlier, my lord.
So
annexed,
that is something this court will not reconsider. It's not a review. You can't come for a review. You ought to have placed all that in the first round.
Yes, my lord. My lord, in earlier bail petition, my lord.
You see, the case diary indicates that during investigation the name of the petitioners have come into light. It appears that the petitioners, after burning the shop of the informant, have been absconding, and because of which the investigation has not been able to take into its logical conclusion. This position still stands.
My lord.
Absconding, because of which the investigation is not being able to proceed. Correct, Mr. Das?
My lord.
You want to add anything?
My lord, one thing, my lord, here, a person was engaged by him. Then, a person was engaged by 4 accused persons. Now, he has made extrajudicial confession to one person over phone who recorded it, and well, thereby their names came out. They were the conspirator.
My lord.
So,
may I
my lord,
say,
this
my
is a
lord,
serious case,
that
and his livelihood has been, my lord, put on fire. My lord.
I am, my lord, with my learned friends, my lord. What is, my lord, came, my lord, in the forwarding report, my lord. One of the accused Kausar Hussain Mazumdar, my lord. He has, my lord, named, my lord, that we were, my lord, in a meeting, my lord. That was, my lord, the allegations, my lord. How we came in the
I'm
front.
sorry, Mr. Counsel, this is not a case of anticipatory bail. Yes, please.
My lord,
take
my
down.
lord, my lord, my
All
lord.
right, Mr. Counsel.
1 minute, my lord.
K. Meera?
1 minute, my lord, may I submit, my lord. Regarding absconder, my lord, it is a 436, my lord, section, my lord. They apprehend, arrest, my lord. There is no absconding, my lord. I have annexed some of the photographs, my lord. It shows, my lord, they were my lord, present, my lord. One of the petitioner is, my lord, he runs a school, my lord. He has, my lord, there is some occasions, I have annexed, my lord, photographs also, my lord, in the school, my lord, he was present, my lord. And, my lord, the informant and the petitioners, my lord, also, my lord, took some dharna, my lord, for the peace in the locality.
All right. We've heard you enough. Heard Mr. K. Meera, Learned Counsel for the petitioner. Stop. Also heard Mr. D. Das, Learned APP for the state respondent. Stop. This is a second application under section 438 of CRPC 1973 for granting of pre-arrest bail to the petitioners, namely Mustaq Ahmed Loskor. All of them?
Yes.
Shaheen Ahmed Loskor, Khairul Islam Tapadar, Faridul Islam Tapadar, and Machum Ahmed Borbhuya, who are apprehending arrest in connection with Katli Chehra PS case number 183 of 2023, registered under section 294, 506, 436, 34 of IPC. Stop. Pertinent that with the order dated 12/3/2024, this court had earlier rejected the prayer of anticipatory bail application made by the aforesaid petitioners upon evaluation and analyzing of the entire materials placed before this court. Stop. There appears no change of circumstances after passing of the aforesaid rejection order. Stop. It further appears that the investigation is not being able to proceed because of the is not being able to proceed since the petitioners are absconding. Stop. As such, the application for anticipatory bail is rejected. Complete mail. This is the complete mail, Mr. Pathak. All right. Where is the prayer?
It starts at page number 7.
Your name?
K. Deka,
Heard.
on behalf of
MSK Deka, Learned Counsel, on appearing on behalf of
petitioner, on behalf of Mrs. R. Devi.
MSR Devi, Learned Counsel for Petitioner. Stop. Also heard Mr. KP Pathak, Learned Standing Counsel, APDCL.
Yes, sir.
Stop. By way of this instant petition, the writ petitioners have been seeking restoration of electricity connection to the petitioner's business premises situated at village Tumuki under Sunitpur district. Stop. Today, when the matter has been called, Mr. KP Pathak, Learned Standing Counsel, APDCL, submits a correspondence received from the APDCL authority via email dated 15th May, which indicates that when the APDCL authorities made efforts to comply with the direction, there was a direction to...
There was an interim direction.
That is dated?
15/12/2020.
Indicating that pursuant to the direction of this court by order dated 15/12/2020 to take steps to ensure that electricity connection to the petitioner's subject premises is restored, efforts accordingly were made. Stop. However, the previous connection appears to be in the name of one Mridul Adityam within bracket 094000 Sarita 0 33461 was permanently disconnected and dismantled on 18/11/2020. Stop. Since the petitioner was not found in the said premises, comma, the APDCL authorities could not restore the electric connection. Stop. It is further stated in the aforesaid correspondence that presently another connection in the name of Ritakar Sutradhar within bracket 094010062986 is being served in the same premises, which was obtained as new service connection on 28/4/2021. Stop. It is further stated in the aforesaid correspondence that the petitioner is not residing in the said premises presently. Stop. In view of the aforesaid correspondence placed before this court on behalf of the APDCL authorities, which manifestly indicates that the petitioner is not residing in the subject premises, and in fact electric connection to the subject premises has already been granted to the person who is residing therein. Stop. That being so, nothing survives for adjudication in the present writ petition. Stop. In view of the above, this court is of the considered view that this writ petition stands disposed of on being infructuous. Stop. However, it is made clear that if the petitioner, this is not required, this is already there.
Yes, Lord.
All right, disposed of.
Perhaps these instructions may be kept on record.
A copy of the said correspondence dated 15 May 2024 is kept on record and placed and marked with X.
Obliged.
All right. Ito kiman number is 3. Disposed of, huh? Yes.
In this council, we are suffering from illness. Operation was going on, madam.
Yes. AB, interim. I don't think there was interim in this case. Interim is not there. When do you want it?
No, after 25, madam.
Huh?
After 25.
It is submitted that the arguing counsel, Mr.
F.A. Hassan.
Mr. So-and-so is undergoing treatment.
On behalf of P. Ahmed, madam. P. Ahmed is undergoing treatment, madam.
It is submitted that Mr. P. So-and-so is undergoing treatment, and accordingly accommodation is sought for in the matter. Stop. Prayer allowed. List on.
25 this is a landscape case, madam. Should we retain the case diary, madam?
In the meantime, let up-to-date case diary be called for.
6th on 31st May. Present.
আজি এসি কিটা অলপ কম হেৰি কৰিছে নেকি চালি চলি আছিলে নেকি
May please your lord.
7 and 8 no case there is there, madam. May be given 10-15 minutes time.
All right, Mr. Abdullah,
Lordship.
wait for a while.
Lordship.
7 and 8.
Almost all case there have come. I will not go through morning.
Anyway, no problem. You let us know when you are ready.
Madam.
This is a part-heard matter.
Could perhaps recall this food adulteration, madam? section 10, subsection 7 regarding that independent witness.
I don't remember anything. Which is this matter?
My lord, food adulteration matter, my lord, whereby, my lord, the inspection was carried out in the premise of the petitioner, and subsequently, my lord, the offence report was given in against the petitioner, and subsequently criminal proceeding was initiated whereby he was convicted. He preferred an appeal that was also
It's
dismissed.
not on here. I don't think this was part heard. Anyway, so Mriganka.
আজিকালি এইটোতে হিয়াৰিং ইনকনক্লুচিভ আৰু ফাৰ্ডাৰ হিয়াৰিং বুলি
Yes, you'll have to refresh the memory of this court because apparently there is no noting in the file.
My lord was pleased to take it up on 28th of March.
That's all right. Just
Page number 11.
just you may brief the you may state the facts in brief. Note that.
Lord, in the year 2008,
What? Just one second. एक खनियात আছে. Oh, sorry. Yes.
on my lord, 20 November 2008.
20.
November 2008.
Yes.
It was conducted in the mill of the petitioner. The petitioner is engaged in the business of manufacturing of mustard oil.
Mustard oil.
And there, my lord, prior thereto, it is the projected case that they have received some kind of complaint that I have been using or supplying or selling some kind of adulterated.
So
based on that, my lord, the raid
complaint was filed by whom?
The present complaint has been filed by the food inspector, but the food inspector raided my premise on receipt of some private complaints. My lord, I have not been aware. So accordingly, my lord, in November 2008, my lord,
সব বস্তুবোৰ ইমান দূৰত কিয় আছে এইটো ঠিল দেচোন দূৰত সব বস্তু কিবা না এই পেনটোত হেৰি আছে এইখন নালাগে এইখন খুলিবও নোৱাৰে The desk was slightly disorganized today. Sorry. Yes.
Then, my lord, the raid was conducted, and during the raid, my lord, certain samples of the oil was carried by them.
Certain samples?
The mustard oil they got in my premise that
Was seized.
That was seized, and subsequent thereto, those seized materials were being for sampling report. And that report came up in the month of December 2008, wherein it was said that there has been some kind of content with regard to
Which
that other
page is this report?
My lord, page number, my lord, 11.
All right.
Offense report. My
The
lord.
report is positive.
Yes, my lord, that is against me. Now, against that, my lord, the criminal proceeding was instituted because, my lord, they filed a complaint before the Chief Judicial Magistrate to take
That
cognizance.
complaint is annexed.
No, my lord.
All right. Then proceedings were
Initiated against me, and my lord, at page number 18, the order of the judgment of the trial court. My lord.
This is what is challenged.
Yeah, this has been challenged. The subsequent thereto, my lord, I went for an appeal that is at page 25. So dismissed.
One second. Page 18 is the trial court order. What is the date?
22nd December 2010.
22nd?
December 2010.
And then you went in appeal.
Appeal. That is at page 25. Date of judgment is 3rd of July 2013. 3rd July 2013.
Yes. So in this revision petition, you have challenged these two orders, the
Yes.
trial code and the appellate code. On what ground?
The main contention is that, my lord, section 10, subsection 7. This is the mandatory provision by virtue.
Who's appearing for the other side, Mr. Das? You're appearing.
State is there.
Yes.
Under section 10 subsection 7 of the act, it says the mandatory provision for there should be an independent witness at the time of conduct of the raid. Admitted fact, my lord, there was no independent witness at that point of time. And the witness were there was the part, the officials were the part of the team. The food inspector, they were being accompanied. So this is my my primary ground. Based on which the mandatory provision has not been taken up. The second thing is that if my lord comes to page number 14, that is the cross-examination of
Page
the
number?
14, 14. That is the cross-examination of the accused petitioner.
Yes.
This is the question number 1, which starts at page number 14. It ends at page number 16.
Yes.
It comprises of one question comprises of 3 pages.
This is a 313 statement. Yes.
So, my lord, the first question that
Mr. Das, this page 14 is 313. Yes. Yes.
so the first question that starts at page number 14 ends at page number 16. It comprises of 3 pages.
Yes.
Under what circumstance the accused could have replied? That aspect of the matter has to be taken up.
I have not understood. According to you, this entire incriminating materials have been clubbed in one question,
My lord.
for which the accused could not have properly
My
answered.
lord.
This is what you are trying to bring home.
And the second question starts at page number 16 and ends at page number 17.
So that is why, according to you, the trial has been vitiated.
Anything and everything that would have been come up, at least some kind of he could have been given
Are you having any authority
to that effect. My lord.
to support the argument that you are making?
No, my lord. Regarding that, no. On
So there are various decisions of the apex court in regards to 313,
My lord.
where because at the end of the day, this is the only opportunity that an accused gets to explain the incriminating circumstances, materials that is available.
My lord.
So there are decisions. Are you having it or not? Huh?
No, my lord.
I think it will be essential that you have these decisions, because if that is one of your ground. No, Mr. Das?
Yes,
There are
there are
ma-
full of facts
Correct.
should not be used
Correct.
in one question.
Correct. You get that decision. When do you want it?
My lord, this week, my lord, any day, because only this small matter.
Tuesday, already.
So small because concurrent finding is there.
No, that is a different aspect. But if the petitioner, if the appellant is trying to develop an argument that because of the adequate opportunity has not been given to the accused to explain, then that itself would be fatal. Correct. But in order to make that, he has to also have some decisions to that effect, that in whether such questions are permissible or not, the manner in which the questions have been put, because it appears that 3-4 incriminating materials have been clubbed together.
The entire offense report has been
But
clubbed
if
together.
there is also the argument, if there is
That is why
something
you
wrong
both
in
have
it had an examination that can be sent back
So
for
you both have these
probable-
authorities ready, because you see, you cannot be hearing these cases in a piecemeal manner. It becomes very difficult. Then this court will forget. So you come up with all the authorities on the point. hearing could not be concluded. List on such and such date for further hearing. এবার এটা থৈ দিয়া
পিছত পেটে সেইটো আগত দিয়ক পিছত
থৈ দিয়াই ভাল না This is a part-third matter. Where is the other side? Mr. Tiwari, you are appearing in this matter?
Yes, my lord, I have already argued it.
This
I
is
believe
that
your lordship.
Labour Court.
Yes, that's it. I have completed my side, Mr.
Yes, Mr. Das Gupta.
Well, I can, if you have nothing to argue, well, I can.
I think that very day itself, your lordship.
Yes, Mr. Tiwari, I remember. You had.
Correct.
However, you may just indicate the facts just in a nutshell,
That is,
just to refresh the court.
Recall, in fact, on the last occasion, I had given the resume of the facts with the relevant dates.
I don't know why, but neither my notings, nothing is kept on the file. Even your, I wrote a second file as well.
Maybe it is in the second file because no
Okay,
copy was given, my lord.
Mr. Tiwari had submitted this. Okay, so no. I don't know how.
There are no notes here.
Oh, this is that settlement matter.
Yes, yes.
When there is a gap of.
I'm sorry, there is a clash between the two cases. So there is some confusion, my lord. I'll just.
No worries, no worries. You see, even there is a confusion this side also because this matter, if I recollect, I had heard you long back.
So anyway, my lord,
Probably
again.
in the month of March.
Yes, yes, yes. So anyway, if your lordship doesn't have it, I'm giving another
I've
call.
got it now. I've got it.
Just a minute, my lord. I'll sort out something with him. Pen.
Mr. Tiwari, you may take your seat now. I have remembered. Yes, Mr. Das Gupta, he had already finished and he has a right to reply. You were supposed to argue, in fact, on the last occasion, on your ground, the matter was adjourned.
no, actually, I was in the court number 1.
Yes, no worries. So you please give the reply. Be specific to the argument made by Mr. Tiwari.
Now, Milord, this is nothing but a interpretation of a settlement. Now, what before going to the portion of the settlement, relevant part of the settlement, let me narrate what happened. So far, Assam Carbon is
The
concerned.
settlement, if I recollect, was subject to conditions. Correct?
Yes, yes.
Yes.
Now, 2 lockouts were there. One lockout was resorted on 24/7/2008. Sorry, 29/11/2007, and it was lifted on 24/7/2008. Second lockout was resorted on 12/2010.
Yes.
And it was lifted throughout a settlement by a settlement dated 21/2/2012. Now, Lord, in between these two months, starting from 2007 to 2012, Lord, there was no revision of scale of pay. Now, the union submitted their charter of demand to revise the scale of pay during the
You are appearing for?
workmen. Submitted their charter of demand, and this demand was examined at the intervention of the consultation officer, and ultimately
They had circulated charter of demands for in case of revision of pay.
a revision of pay. This is, so far this settlement is concerned, this is with regard to the revision of pay. Now, what happened, Lord? It was agreed. All right, we shall pay. The basic salary was fixed. Dearness allowance was fixed. But one condition was imposed, that in order to have this basic salary or the variable dearness allowance, you must maintain the productivity. That is the condition. And so for the area,
Yes.
so for the area wage is concerned, Miller, a lump sum amount was fixed. That is, that was fixed to the extent of rupees 1 crore. Now, so this amount, now the basic question is with regard to this area salary, rupees 1 crore.
Rupees?
1 crore. Lump sum amount that will be adjusted throughout the due procedure. Now, management's case is that though there is a provision for area pay of scale, but it is subject to the condition for the fulfillment of the productivity. And you have not fulfilled that productivity criteria. And as you have not fulfilled the productivity criteria, you are not entitled to this area.
Yes.
This is the, so far this case is concerned.
Correct.
Now, all these things are narrated in clause 2, A, B, C and D parts there. So
Yes.
far A, I will place a triangle, just give up here. So far the A is concerned, it contains about the basic pay. D is concerned, it contains about the dearness allowance. So far C is concerned, it states that you can get this basic and dearness provided you fulfill these conditions. And so far D is concerned, we have fixed this area pay of rupees 1 crore, and that will be paid subject to the conditions of the fulfillment of the productivity. Now, A was released, B was released, and A and B was conditioned with the fulfillment of productivity. If these two things were released, then how the remaining question will...
How?
But A is concerned, clause A is concerned, that amount was released. So far clause B is concerned, that amount was also released. And clause A and clause B were conditioned with that, the fulfillment of the productivity. So when this was released, one should presume that the productivity fulfillment has been fulfilled.
One should presume what?
That the productivity...
No, that will depend on at that. It has to be just because one has achieved the productivity at one stage doesn't mean that all stages it has been also achieved. It will be reviewed, and at a particular stage before releasing, if that has not been achieved, isn't it, Mr. Dasgupta?
Yes.
Because here at the third stage, I think they had stopped. Correct. At the third stage, they had stopped.
No. Have not stopped anything, good. They have only stopped
Some payments were made. Initially, some payments have been released, correct?
No, initially not. So far, your Lordship come to page 31.
Page 30?
31.
Yes. This is part of the...
No, this is the settlement.
This is a settlement.
Now, this settlement contains, so far, dispute is with regard to clause 2. Clause 2 contains 4 parts, A, B, C and D. Got it?
Last time I had marked 3 parts. Yes, sir.
Yes.
That is the core issue.
Correct, I have it. Page 31.
Page 31. 4 parts, A, B, C and D.
Yes. Come to D.
Now come the the strict adherence of NHPC norms and achieving the maintenance agreed productivity norms from the date of resumption of operation. Now, in order to appreciate D, we should go first A and B.
All right.
We can understand D.
Yes.
Simple thing there. Now, so far revision scale is concerned, one must fix the basic way and the challenge. So far BCKY is concerned, it is at 2A. The revised wages of the workmen covered under the agreement at average rupees of 1569 per workman per month. Detailed calculation would be worked out in due course as per the prevailing practice at other units. They have the other units at Calcutta as well as Hyderabad. Revision will be effective after the achievement of productivity. This is very much important. This revision will be effective after the achievement of the productivity continuously for 2 months. 2 months, effective date of this revision will be the first day of the following month. This settlement was arrived at on 21/2/2012 and effective date will be 1st of March 2012.
1/3/12.
1/3/12 as it appears. Revision will be effective after the achievement of productivity continuously for effective date of the revision will be first day of the following month after the workmen have continuously achieved and maintained productivity at all specified process stations work stations according to the NTP norms during the preceding 2 months continuously without any break. Now, Milord, so far this thing is concerned, it was released. Your Lordship will find in their evidence itself here.
Yes.
I am giving this page number. Page number. Their evidence is that, yes. It starts from page number 50.
50.
Now relevant, so far other cases not very relevant. Now relevant is straightway after. Now clause 14, 15 and 16. No. On the terms of settlement.
Page.
57.
There are 13 also below better.
No, page.
Page is 56. Para 13 onwards.
Was that
Right, Mr. Tiwari, let Mr. Dasgupta. I do not appreciate the disturbance.
Let him argue.
Yes, let him.
Let me satisfy him.
It's all right, Mr. Dasgupta. You can carry on with your own flow.
No, so far para 30 is concerned, it's not relevant so far the terms of it.
That is.
Paragraph 13 of this
Not
evidence.
30, 1-3.
1.3 is concerned, that is not relevant in these terms of reference. For the
All right.
now, Your Lordship, just take the terms of reference.
1-3 of evidence. What of reference?
Just a minute. Now, what is the reference? Reference, Your Lordship will find at page 81.
Whether the management of Messrs. So-and-so is justified in
Payment of
denying.
Assam Carbon Products Limited, Birkuchi, Narangi, Guwahati is justified in denying the payment of rupees 1 crore. Now, 1 crore only in terms of clause 2B of the memorandum of settlement. dated 22/12/2012 to other workmen. Now, if not, whether the workmen are entitled to commutate this amount. This is only. That is with regard to the clause.
Correct.
Just a bit for his satisfaction. No? If we also come to page para 13, para 13 is something else. It is pertinent to mention here that during pendency of the application under section 33(2)(b), the union raised an industrial dispute regarding the lockout and dismissal of 27 workmen on misconduct. The labor cum conciliation officer hold conciliation between the management and the union, and there, after a protracted discussion of the issue, the management and the two unions have arrived at a settlement at 22/12/2012. 21/2/2012 in presence of the Assistant Labour Commissioner Guwahati. But so far this issue is concerned, that has not been referred. 21 in presence of the Assistant Labour Commissioner Guwahati, as per terms 2 of the said settlement, the union agreed to achieve maintained productivity norms as per NPC. The management has also continuously agreed that if the union strictly adhere to NPC norms and achieve the maintaining agreed productivity norms from the date of resumption of the operation, in such case, the management as a goodwill gesture will offer retrospective period one lump sum payment towards both charter of demands and all other financial demands in any form on the date of this settlement of the total financial implication company being restricted rupees 1 crore as full and final special case without creating any precedent. However, any failure in achieving and maintaining the agreed productivity norms in any month,
this is important,
disentangle the workmen to such lump sum amount, management will deduct the lump sum amount from the wage. That is with regard to clause D, Miller.
Correct, but that is one of the condition of clause 2.
That condition will find at clause D.
Yes.
Page 31.
And this is because this amount is being paid to the, yes, continue reading.
Clause 13, paragraph 13. As full and final settlement, special case, and without creating any precedent. However, any failure in achieving and maintaining the agreed productivity norms in any month will disentitle the workmen to such lump sum amount, and management will deduct lump sum amount from the wages of the workmen in the same manner as it paid. This is because the amount being paid to the workmen as a goodwill gesture based on assistance and the agreed productivity norms will be achieved and maintained during the operation of this agreement. Subsequently thereafter, without any interruption until further agreement is made. Exhibit 7 is that settlement.
Yes.
This is nothing but the clause D. You will find at clause D. They have quoted this clause. They have.
Yes.
Now, if you will also come to clause D at page 31.
Yes.
The 57 the management as a goodwill gesture.
If I have understood it correctly, the 1 crore agreed will be released subject to achieving the target.
Yes.
The target has been fixed.
Production
target.
Now, yes, that is the only simple case. Now, for that purpose, we have to appreciate clause A and clause B. If clause A is also conditioned with that if you can achieve that target, then and only then you will get the benefits as contained in clause A. Clause B also same thing. That if you can fulfill the productivity target, then you will get these things. Now, both this clause amount due to clause A and clause B were released.
Both these clause was?
Clause A and Clause B, amount due to Clause A and Clause B
Has been released.
has been released.
Yes.
That your Lordship will find at paragraph 14, paragraph 15, 16
Of
their evidence. Starts from
MW1.
which starts from page 51. Easy guys. Well, yes, we have released, but it was released on humanitarian consideration. That is their case.
Yes.
51. Now, I have read 13. 13 is nothing but the clause
All right.
2D.
No repeat. Yes.
Clause 14. That the what is their understanding? From the terms of the settlement, it is clear that the revised wage payable to the workmen only condition achievement of productivity, as per NPC norms continuously by the workmen. Similarly, the lump sum payment also conditional. That is, revised is A and B, and lump sum payment is, that is area, conditional. That is, after the workman achieved and maintained the productivity which is known as agreed. So A, B and C, A, B, C and D are both linked with the productivity norms. It was also one of the terms of the agreement that the failure to achieve the maintain the agreed productivity norms in any month will entitle the workman to such lump sum amount, and the management will deduct the lump sum amount from the wages of the workmen in the same manner as it is paid. However, after lifting lockout, what is their own case I am telling you, however, after lifting lockout, the workmen have failed to achieve the productivity norms as per NPC. In fact, they never achieved the productivity norms. That is their case. And our case is, we have achieved. I will refer to you. Let me start with their case first. Now, after saying so, what they have said there? Paragraph 15. Even after failing to achieve the productivity norms as per NPC, the union started pressurizing the management for release of the amount as mentioned in clause 2 of the memorandum of settlement. After much discussion, the management on humanitarian consideration, with a view that they would encourage the workmen to step up their productivity and readily achieve their productivity as per NPC study, release the first part. So whether it is on humanitarian ground or something else, one must presume that you have released these things. Release the first part of the revised wage on dated 21/12/2012, with effect from 1/4/2013, conditionally and subject to the fulfillment of the notice. They have not exhibited any such order to that effect that they have conditionally. Now, second, even thereafter, there is with regard to fulfillment of clause A. I got it?
Yes, yes.
Now, fulfillment of clause D. That even thereafter, the workmen have not any time achieved the target of NPC. Well, we have released these things, despite that you have not achieved these things. That is their content. Norm. And failed to fulfill the terms of the settlement dated 21/2/2012. Yet, both the union made several appeals to the management for the releasing their wages as per the settlement. After several discussions with the union, management on humanitarian consideration as a strong motivation released second part of the revised wages. The condition is that, yes, you have released clause A and clause B. Now they wanted to say, that though you have released, but that was not in terms of the settlement. That was released only on the humanitarian.
On the expectation that you will reach the target.
We will reach the target on the expectation. We have released these things. Now, how the settlement has to be interpreted.
There is no ambiguity in the settlement. It's very clear, the terms of the settlement, that this is the target, you achieve, and if you achieve it, you will get it. That is the settlement.
Oh, yes, that is the settlement. Now, what is their target? Now that your lordship will...
Just because they have considered releasing the first two parts, even in a situation where you have not achieved target, that doesn't mean that they are entitled to release the entire amount. When despite releasing the first two parts, you have not achieved the target.
Oh, that is their case.
So that is very correct approach.
Correct.
But is that an admitted fact, Mr. Tiwari, that the first two parts have been released with the expectation that they will, that much is admitted. So if that is done, they are.
In addition,
on the.
Yes.
Okay.
In addition, that they achieve it, correct?
On expectation that they will achieve the target, that is one part. Settlement is concerned. This settlement gave rise to two cases before the labor court. The present case we are dealing with. The other case also linked with they maintaining the target.
There are two cases.
Two cases. In other case, because it is not only the revision of wages and also the lump sum amount of 1 crore. Apart from that, there are other demands also, which were integral to the settlement.
So that is in a different case.
It is in a different case, and there the labor court gave the finding categorically that they could never achieve the target, and that we have annexed the award of the labor court.
Mr. Dasgupta, you are also admitting to the fact that you have not achieved the target. Huh?
No.
You are saying you have achieved the target. But anyway, that's a disputed question. Now that has to be decided on the basis of evidence.
Yes, that is a disputed question.
The
that
Labour
has to,
Court ultimately has come to what finding, Mr.
that
Tiwari?
they have achieved this
That
thing.
you have-
They have
No,
achieved this
labor
thing.
court didn't say so.
All right.
Labor court did not say
No.
they have achieved it. Labor court rather said this settlement is a camouflage.
Oh, right.
Number one.
Yes, I remember.
Labor court also doubted the authenticity of the settlement. So there is great degree of ambiguity and crossword puzzle so far as the interpretation of the award of the labor court is concerned.
All right.
They have spoken in multiple voices.
So,
Yes, Mr. Dasgupta.
the finding of the labor court in this regard, and what is our contention in this regard? If we have stated in our WS, not only that, when
According to you, since you have achieved the target, you are
not
entitled.
only according to me, according to them also, my lord, because they
No,
have.
but what I am saying is that your argument is that since the targets have been achieved, so it is imperative for the management to release the agreed amount.
and-
Correct. That is your.
That is only one contention.
Yes.
Now, let me substantiate this contention first. Then I will go to other point. We have adduced our evidence, and we were also cross-examined. And what is the cross-examination? Lordship, come. Well, page 70.
70.
You are cross-examined, where we have stated that we have fulfilled, and on that point, my lord, examined.
Yes.
My second paragraph, my lord. The first paragraph is not relevant. There is a tablet. It is not a fact that we failed to fulfill the norms by NPC. This question was asked. There is a suggestion. It is a fact that MOE is dated 21/12/2012. We assured of giving production as per the norms set by NPC. The operator used to submit the report. Operators used to submit the report of production shift-wise as per the norms by the production in charge. After signing of the MOS, our salary has been increased twice. I produced Exhibit A before this court to show that we have received more benefit than MOS. So far the productivity is concerned. Now, if your Lordship just come to settlement again. Page 31. Case is in a very narrow compass. Now, clause 30. Your Lordship will find at page 37.
You want me to come to page 31 or 37?
No, it starts from 31. Relevant portion is apart from 30, relevant portion is clause 30. That is at page 37.
Yes.
It is agreed. It is agreed by the parties to the agreement that the machine operator would give daily production report against the targets along with the reasons for shortfall. If any, shortfall if any. Now here our condition is here, we have already fulfilled this petition and we have submitted the reports to them. Operators would be responsible for quality of parts and produce, and any failure, exercise, rejection shall be treated as a gross misconduct. Gross misconduct. It is further agreed any failure in giving daily signed production report would amount to absence from duty. So, we have submitted our report. Daily report. It is not that we have not submitted, because had it been so, then the operator would have been implicated to a disciplinary proceeding.
Yes.
And at no point of time raised that you have failed to achieve these things. Now, when they have started, now if your Lordship comes, that is one point below. And in this regard, our statement in the evidence is that we have submitted our report, our operators have submitted the report, and it is not, at no point of time it was raised. Now, my Lord, when they have started to assess whether we have achieved the productivity or not, you will find page 60.
Page 60?
60.
Yes.
60. That is their evidence.
60?
60.
Page 60 is only the affidavit page, I think. What do you want to show from here? The worksheet?
It starts, it should be start from 59.
Yes, I think from 59. Para 20?
Para 20. Yes. Now one has to assess and it will be assessed. Is one of my
By showing this, you are trying to you're trying to prove that the target has been achieved. Correct?
That is one thing. At this point, Lord, I am on this point. Second point, I will argue.
Yes, yes.
Please.
No, I'm just trying to understand in what context you are showing me.
Yes.
All right.
Second point will be defined, Lord. That way I will. Now, Your Lordship comes. According to them, they assess from 1 to 21. Now, Your Lordship will find the deponent begs to state that the management is fully satisfied, fully justified in denying payment of one course only as per item number 2 of the memorandum of settlement dated 21/2/2012 to the workman, as the said lump sum payable was conditional. That is, after the workman achieved maintained productivity norms. It was also terms of the settlement that failure to achieve the agreed productivity norms in any month will entitle the workman to such some amount and the management will deduct, if paid, the lump sum amount from the wages of the workmen in the same manner as it paid. However, after lifting the lockout, the workman has miserably failed to achieve the productivity norms as per NPC in this regard. The management has issued letter on 12/11/2013. This is date में calculated. To the General Secretary of the Union and enclosing a detailed worksheet showing the low productivity level. Even then, Union failed to achieve productivity norms set by the NPC study report. Exhibit 9 is the letter dated such and such. Exhibit 9 is my signature. Now, when they have started assessment, assessment from 1 to 2013. I got it?
Yes.
Are the worksheet from Exhibit 9A is my signature there on Exhibit 9 are the worksheet from 1 to 2013 to October 2013.
Yes.
Now, settlement was arrived in the February 2012. Production resumed in the March 2012. And they started to examine these things from 2013 and to October 2013. In the meantime, Miller, they have released
two parts.
Parts.
So which part of the Labour Court judgment, in the Labour Court judgment, they have come to a finding that the targets have been achieved? Where is that finding of the Labour Court, Mr. Dasgupta?
Yes. Labour Court finding is twofold.
No, first you please show me that particular finding.
Now you have come page 87 and 88. If you read page 87 and 88, that will be clear.
Yes, I have page 87.
So they are relying upon Exhibit 9, and they, this aspect of this case
Yes,
was
come
dealt
to the finding.
Huh?
Read the finding.
That is page 87.
Yes.
Was also submitted that exhibit. Okay. In Exhibit 9, 114 items produced jointly. The two.
Where are you reading from? Which part?
Let me start page 87.
Yes, I have page 87 from the top.
Top.
All right.
Yes.
All right. Okay.
Yes, let us stop. In Exhibit 149, that is they have relied upon, and 193 items were produced jointly by two operators. In Exhibit 149, two separate NPC targets have been set for the same item. Grade was of P. Kalita and J. Das, one target, and while these things, no explanation from the management, P. Kalita, the target was set 5. Let me read it again. In Exhibit 9, within bracket 149, two separate NPC targets have been set for the same item, grade.
It's all right, you've read it, I've understood. That for the same target, two different
targets.
For the same item.
Same item.
One 570, one 291.
Yes.
Okay. And there was no explanation.
No, there is no explanation.
All right.
That is there. It may be correct, it may be wrong. That is different thing.
Next para.
Next para. On the side of the workmen, that the payment of ₹1 crore to the workmen in 4 installments is no way related to the performance of the workmen. That is one part. NPC report. Therefore, meticulous examination of MES that is 21/12/2002, more particularly the examination of the Memorandum of Settlement, Exhibit 12/2/2012, it is seen that the lump sum rupees 1 crore is meant to the workers for works already performed. It was written in the said memorandum, that is defined as settlement. It was settlement that it is not para 8, para 3 of the management as a gesture, as a goodwill gesture will offer to the retrospective period one lump sum amount towards the both two charter of demand and other financial demands any form of residence. It shows that the management committed to the workmen to pay the amount with retrospective effect, and it was a goodwill gesture on the side of the management. There is another significance, deviation from the side of the management, that though the workmen are cautioned that NPC norms must be fulfilled for securing the installment of the lump sum amount of rupees 1 crore would be assessed quarterly before making the installment of lump sum amount, but Exhibit 9 onwards, it has not come to the performance of the worker assessment. What he wanted to say is, by inserting clause D, that is against the operation of law. It is one aspect. I am not at this stage in these things. I will make my argument later on. What he wanted to say, that for clause D is concerned, it is with regards to the area report. That is with regard, and the lump sum amount have been paid, not in detail, 1 crore. Now that area pay means that I have earned this, and you cannot take away my earning by inserting this clause. That is one aspect. Well, I have also checked up these things today morning itself.
But Mr. Dasgupta, how can the Labour Code go beyond the terms of the reference? The factum of the settlement is already there. Now, only thing is whether one is justified in
that's all right.
One cannot interpret that settlement any longer.
Let me assume that he has committed a wrong.
Only on that part. I am not on the other part. But as far as that part is
Yes,
concerned,
in my mind
there
also.
is no ambiguity in the settlement which calls for an interpretation. It is very clear.
Yes, that is clear. Whether the question is that
now whether that is right, wrong, that is not for the Labour Court to decide, because that is not the subject matter.
No. Yes, that is not the subject matter as it appears from the terms of the settlement.
Absolutely, one will have to go as the term has been framed. If there was any, if it has been wrongly framed, one could have approached earlier and got it corrected. That is not the situation. You have submitted yourself to the terms framed.
No, let me.
Yes.
Now, come to this point. Section 2P.
Section
2P of the Industrial Dispute Act.
Rupak, ID Act.
We shall come later on this.
ID Act.
Let me justify these things. Okay. Now, let him find it out. Let me go further. Right? Moreover, that is one contention. That is, your Lordship is asking me the questions. No, it is not the duty of the Labour Court to examine. Labour Court has to assess in terms of the settlement. Labour Court has to assess in terms of the settlement, and he cannot examine these things. That is your Lordship's. I will answer this question. For the timing, let me keep it in a...
No, in a way, see, he has to confine himself to the terms of the reference. He cannot now go and see whether the settlement is correct, not correct. That is not the terms of reference.
That is not the terms, but the
terms of reference is whether that 1 crore, whether it's justified in not giving the 1 crore. That is the terms correct.
At this stage, I will not...
Let me see that term again. The reference. whether the management of so-and-so is justified in denying the payments of 1 crore only committed in clause 2D of the settlement. So that is the only term. And if not, whether the workmen are entitled for the committed amount.
When your Lordship is asking this question repeatedly, so I will refer.
This for the labour code, it is imperative the labour code will have to answer the reference. Correct. I don't think there is any change in the law. That is how this code understands.
For that purpose, your Lordship, please go through section 10, subsection 4.
Wait, but that
will clarify the situation.
Section?
At this stage, I would like
section?
Section 10, subsection 4. Actually, my intention was to argue this point afterwards. Let me first start these things.
Oh, but when you have touched that point.
All right.
Yes.
Say subsection 4.
Yes.
As an order of reference, referring an industrial dispute to a labor court tribunal or national tribunal under this section, this is section 10. Under this section or in a subsequent order, the appropriate government has specified these points of dispute for adjudication. The labour court or the tribunal, as the case may be, shall confine the adjudication to those points. That is your Lordship.
And matters incidental thereto. You want to stress that part?
Yes, sir.
You see,
yes, your Lordship is correct.
I don't know. You may be anyway. Since you have you are arguing it, this court will have to answer it. But
without arguing this point, I can succeed. If required, later on I shall argue these things. To refer Article 23, all these things. It will make a lengthy argument.
There are several decisions also of the apex court, which is very clear that
one thing is let us agree.
I'm sure there is a decision where incidental has been.
Labour court cannot go beyond the terms of reference.
Correct, and that word incidental that is appearing in subsection 4 of section 10, I am sure there are decisions which must have interpreted what it would mean, because it would not mean that now the settlement itself is at large before the labour court and he can go into the settlement and see whether the settlement has been is valid, not valid, because that is not the terms of the reference. Now, in connection in relation to the justification of denying the 1 crore, there may be something ancillary or incidental that one can go into.
All right.
But here,
for the timing,
settlement will be presumed to be valid.
For the timing, because,
anyway, proceed.
Because wastage of time, which will be for the timing. Next one. Moreover, Exhibit 9 onwards, it has come to the performance. I will argue later on. Moreover, it has come to the evidence of Mr. Saikia, that is NW1, that against Exhibit 9, Union submitted a reply, but the same has not been produced before the court by the management. Mr. Kolita has also submitted that none of the workmen was so caused when they allegedly found not fulfilling the norms set by NPC. There is an appreciation letter from the chairman, which has been exhibited from the workmen's side. Exhibit B. Exhibit B is a letter by the Workers' Union and the chairman of Assam Carbon Products Limited. Said later, a remark of the chairman was reproduced as follows. On 13/7/17, our honorable chairman has addressed two groups of workers separately with the factory premises, wherein he appreciated that all workers for their sincere and hard work resulted to a good record of production, in quality and in quantity in last 3 years, and as well as the earning position in trustworthy name of Messrs. Assam Carbon Products Limited, in the market of national and international scenes. International. All workmen in the atmosphere to encourage after receiving the acknowledgement of the dedicated handwork from the Honorable Chairman. Against this settlement, that is one aspect. No? Against this settlement, against this statement, Exhibit B, there is no counter from the side of the management. The most important fact is that neither the oral evidence nor the documentary evidence from the side of the management, the period taken for consideration securing the lump sum period, lump sum amount, securing the lump sum amount by the workmen is specifically mentioned before this court. It was also not informed to the workmen that what would be considered for securing this lump sum amount. Lump sum amount. In clause C and clause D, that is his interpretation. Yes? In subclause C and subclause D, in clause number 2, it was made specific that the revision of wage is subject to the fulfillment of norm. That is his interpretation. Subject to the fulfillment of norm, and it will start from the resumption of operation. That the operation was resumed in the March of and they started assessment in the March of next year, after 1 year. On the other hand, the lump sum amount for the retrospective period and it was a goodwill gesture on the side of the management, and it includes the 2 charter of demands and other financial demands as on the date of the settlement, that is on 21/2/2012. If that be so, if that be so, the future action of the management can be clubbed together with their past dues settlement. That is, again, he is coming to that aspect. Let us keep it up. Suppose the workmen will never able to achieve the NPC. I mean, it is justified to deprive them from their past. That is his query. So what he wanted to say, yes, you have earned these things.
By going into all this, he is travelling beyond. You see, that is why this quote is saying, because ultimately this is showing that he has travelled beyond the scope. It is not for him to decide all this whether will it be justified or because of this, because of the fact that they are not being able to. At the end of the day, these past dues, there was a dispute, correct, going on. They have not admitted their liability for these past dues. There were lockdowns, various factors. Be that as it may, as a good gesture, they said, all right, we will give you this, but as a lump sum, provided you achieve so and so. This is what is the settlement, clearly, right? Which you have accepted. Now, for the labour court to say, in a given situation, if this target is not achieved, will it be justified to deprive from their past dues? This is slightly out of
the timing. Let me skip it up. Now, let me confine with this aspect. They have achieved the national productivity according to
that is the crucial issue.
That is the crucial. Let me skip it up. Let me skip it up.
Because if it is seen manifest on the record that they have achieved, then they have to make the payment as agreed. Simple and short. Then they are not justified in withholding. Correct.
Yes. So, settlement was arrived at 21/2/2012, and it will come effect from 1st March 2012. Now, Millard, they have started according to their own evidence.
Assessment on 1/2/13.
1/2/13. And so, what about this? Our case is that we have all along, every day, our operators have submitted the report. And never raised any objection whatsoever. And had it been so, then you would have taken some action, disciplinary action
For
against
what? Disciplinary action for what?
for not submitting the report. We have submitted that report, and you have never said so that you failed to achieve these things. On the contrary, you have released our
First two parts.
two parts.
No, but in those first two parts, the explanation is there.
Yeah, first,
On
but
humanitarian ground.
yes, that explanation is in the evidence, but there is no such order whatsoever.
All right. All right.
There is no such order itself whatsoever that we are releasing this thing there, as though you have not fulfilled this thing, but as a gesture of goodwill
All
to
right.
encourage you, we have released this thing.
All right.
They have stated in the court itself that as a gesture should be taken. Now, if your lordship, now what is this contention? Contention is that two rival contention. One is that we have achieved the productivity. Management contention is that you have not achieved this contention. So burden lies on whom? Management. That they have not achieved this. When it will be started? It will be started immediately after the resumption. When it was resumed in the month of transfer from the evidence MW. They started their assessment from 1 to 2013. 1 year after the settlement. It is apparent from their evidence of MW at page 50. They have started. It is not that they have not started it. Okay. According to them, they are denied the claim of the workman in the year 2015. So that is my case. Now we have also statement as well as the our additional written statement as well as our evidence. We have stated that we have fulfilled this thing and you have released this thing. That is one aspect of the statement. The other aspect of this case is concerned. If your worship permit me, then I will argue.
Which is the other aspect? The other aspect beyond the terms of reference, that part.
Beyond the terms of
That I don't think is necessary because it is all, you see, there are various decisions on that. First you have to show, if you are successful in showing that you have achieved the target, then of course it has to be given. But if there is no evidence to show that you have achieved, then of course they are justified.
Yes. Now, when this liability will come.
Anyway, yes, Mr. Tiwari, you're finished? Anything else?
Yes. One thing that
But you can also probably a written argument from both sides perhaps would be of some assistance because this court is hearing this matter after a gap of 2 months. So
My lord will give me 15 days time. My lord, the difficulty is because
Take
for
your
next
time.
2 weeks,
Very well.
in the outlying bench.
It's all right. You take your time. I will post it on another date. On that date, you both parties can submit your written
Very well.
arguments, and thereafter I shall reserve it.
Very well.
And maybe on that day also this court can deliver the.
Very well.
We will see. We will see what is to be done on that date.
better.
Yes.
Because I am on the point that so far Section 4 is concerned, probably Labour Code has not done wrong.
Section?
Subsection 4.
Subsection. See, for that you show me from a decision because
that is not
ancillary
written.
would not mean that the
I
entire
don't-
settlement itself will be now the Labour Court will decide whether the terms of settlement was fair or not fair. That is not the reference,
Yes.
isn't it, Mr. Tiwari?
That's it. The law is very clear on that.
That is very clear. The
The
law is
only
very
thing
clear.
is that-
Unnecessarily,
only thing
let
that
us
whether we
not
have-
stretch to that far unless
Gone into the validity,
Correct.
questioning the
Let
validity.
us
unless
ignore.
you have a decision to that effect showing that yes, in a given case, even the validity can be gone into. Then you can show me that authority, and then we can go ahead with this point. Otherwise, no point in unnecessarily going into going that far because it's a very settled law. Incidental and ancillary would mean something in that relation.
Directly
In
related,
here.
directly related to reference.
Correct. Not to the validity of the settlement. That cannot be. Anyway, if your submissions are over,
Well, I wish on the.
yes, Mr. Tiwari, you want to add anything?
Not yes, I can, but seems
Let
that
us submit our written argument.
Very well. In case you want to add anything,
After submission of the written argument, we should have to explain this thing. Yeah?
right now I can explain certain things, but anyway.
all right. Then in that case, we will keep it on another date.
Lordship,
Yes.
let him know, no problem.
My
Yes, yeah.
esteemed colleague, my lord, my esteemed colleague referred to the so-called letter of the chairman of the
No, this is
corporation.
just a minute. I'm very sorry. This is my secondary point.
Okay.
Okay.
The primary point being, my lord, I asked myself as to whether there is any categorical finding, and rightly, my lord, also came out of your lordship, as to whether there is any categorical finding of the London Labour Court as to whether the targets are achieved. The answer is, my lord, emphatic. No. There is no finding. The Labour Court, my lord, number one goes into the validity of the reference. Number two, he says it's a camouflage, lastly. Thirdly, Labour Court also says that, well, it is for the earlier work performed by them. Earlier work, there was a lockout. Then the Labour Court tells itself that after all, the money should be given to them. Why should they be denied it? So practically, my lord, the Labour Court is not entering into the pertinent question as to whether the targets were met or not. Now, my lord, the argument is the fact that, my lord, the relevant papers pertaining to the earlier periods are not produced before the court. So, therefore, the presumption is to be drawn that the target were met. I'm sorry to say this is no evidence at all. If that be the case, my lord, they could very well have asked for something.
All right.
All said and done, my lord, we have shown X, Y, Z and document, namely February 2013 to October 2013. Those exhibits clearly demonstrate that the NPC targets were not met, certainly during that very particular
In
period.
your written argument, you please point out those things, because whatever you have given in your reply, you have seen this court has also asked those questions.
Everything I will
At the
explain.
end of the day, this is what has to be
Yes,
seen.
yes,
Now,
that's it.
If there are findings, if those evidences are there, in that manner, the reference has to be answered.
That's it.
All right.
The only
When
thing
do
is
you
that-
want it?
I'll pray that, my lord, because June practically, my lord, 15 to 20 days, I will be
Select a
heavily
date.
preoccupied.
Select a date.
So, my lord, just before the vacation,
Part list again on
before the vacation, written arguments will be there.
20th June.
Would it be, my lord, after that?
Otherwise, it becomes difficult. If it's a part-third matter, you cannot take it too long. Also,
Let it be, I'll try. I'll
20th
make
June.
written argument. I'll try.
20th June, within 7 days, it can be done. Right?
For 2 weeks, I'm going to be
Oh,
So
actually.
Tiwari has some difficulty.
Then all right.
in the outline bench.
All right.
Maybe 16, no? এখন তাহাঁতৰ কিতাপখন ৰূপক All right.
May it please your lordship. Lordship has earlier dealt with the matter, my lord, but of course those petitioners were under 439. Now these petitioners were under
Earlier rejected.
earlier lordship had dealt with some other accused persons under section 439. Those persons were arrested. These petitioners were under section 438, pre-arrest bail. So lordship's order is at page 15. So my submission is same, your lordship, that these persons have not taken any active participation. They were there. They were there, but they have not taken any participation. Same order.
So here, this petitioner also, upon hearing the hue and cry, had came out of their house and they went near the place of
and
occurrence.
somewhere it's and petitioner number where state that he was not present also, my lord. He didn't.
P2.
Two. The petitioner Amdadul Haq.
P2 not present.
He came very late. And others were just came, they did not took any active participation.
Yes, Mr. Das.
My lord, yes, case diary is received, my lord.
P2 was present.
The presence is there, my lord.
P2.
But the presence lately, my lord.
Yes, he is present, my lord. Independent witnesses have stated. My lord.
That he was present throughout.
My lord. Now, one thing, my lord, the independent witness also says that dispute relating to lands are also going on between the parties, and basically there was a mutual fight on the day of occurrence. Some dispute arose, altercations took place in the self-help group meeting. Thereafter the occurrence of market took place. Now, as per independent witnesses, both the parties received injuries.
This is anticipatory bail.
Anticipatory bail.
Let him appear then. Because it appears that there is no other incriminating adverse materials against their antecedent, correct? That is not there.
Group fight is there, but personal attribution.
That's right. That
personal
is not.
attribution is not there.
Correct. Those are not
That
there.
Saidul inflicted these injuries.
No, those are not
so
there.
That narration is not there.
And the evidences, the statements that has been recorded under 161 does not say that the present petitioners were armed with lathi or anything.
No, that is said. Both the parties armed with some arms.
So basically there was an altercation.
Altercation and group clash, mutual fight.
Okay. All right.
And land disputes are also going on between the parties.
Heard
So
Mr. S.M. Abdullah P, learned counsel for the petitioners. Also heard Mr. D. Das, learned APP for the state respondent. Stop. This is an application under section 438 of CRPC for granting pre-arrest bail to the petitioners, i.e. 1, 2, 3, 4 and 5, who have been apprehending arrest in connection with Rupahihat police station case number 15 of 2024, registered under section 147, 148, 149, 341, 325, 307, 302, 506 of IPC. Stop. The case of the prosecution is that on 28/1/2024, an FIR has been lodged alleging inter alia that on 27/1/2024 at around 3 p.m. in the daytime, an altercation took place between the informant's father and the accused persons regarding distribution of certificate of John Junali Women's Self-Help Group. Stop. It is the further case of the prosecution that thereafter, approximately 1.5 hours later, the accused persons equipped with sharp weapons like lathi, dao, etc. in their hands came to the government road in front of his house and assaulted his father with lathi, dao, etc. as his father was alone and threw him on the ground. Stop. As a result, his father sustained grievous injury and ultimately succumbed to death. Stop. Page 60.paba. Mr. S.M. Abdullah P, learned counsel for the petitioners, submit that the petitioners are no way involved in the case as stated in the FIR, and that the petitioners are the neighbors of the informant, and on 27/1/2024 in the afternoon, they heard some hue and cry on the roadside near the house of the informant, and after hearing the same, they came out and went near the place of occurrence. And since they were present at the place of occurrence, they were arrested. Stop.
They are apprehending arrest.
They were they are, and since they were present at the place of occurrence, comma, they are apprehending arrest. Stop. Mr. D. Das, learned APP, on the other hand, strongly opposes the prayer for anticipatory bail. Stop. He submits that the investigating officer has collected statements from witnesses who have stated that the present petitioners were present at the place of occurrence. Stop. He further submits that there are materials available on record which indicates that there was a scuffle, there was an altercation stroke scuffle between the informant side and the accused group. Stop. That's it. I have heard the submissions made at the bar and have perused the materials available on record. Stop. It appears from the materials available on record that pursuant to altercation between the informant side and the accused side, in which both parties have sustained injuries, the incident occurred. Stop. It further appears that there is any adverse report as regards the antecedent of the petitioners. Stop. The investigating officer has also not placed anything on record to indicate that the petitioners shall not cooperate with the investigation and or flee from justice. Stop. Considering the totality of the matter, this court is of the considered view that custodial interrogation of the petitioners may not be necessary for the ongoing investigation. Stop. Accordingly, the petitioners named above, in the event of arrest for the aforementioned case, shall be released on furnishing bail bond of rupees 30,000 each, with one surety of like amount to the satisfaction of the arresting authority, subject of course to the following conditions: 1, 2, 3, one not within 10 days.
Within 10 days.
And return case diary with the above observation and direction, anticipatory bail applications test disposed of. Just add one line in Abdullah's submission, that he further submits that the petitioners are ready and willing to cooperate with the investigation. Yes. This is item 7.
7.
Item 8 also you are appearing.
No, my lord.
That's a different case.
Not
Is there? Is there, no?
On the last occasion, press call for. Occasion after the CD.
I cannot hear you. Please speak loudly.
On the last occasion after the CD was called for. On the last occasion.
Yes, you've already heard Mr. Das have said case diary is available. Yes. What is this? AB. A fire page.
FIR page 10.
Page 10?
Page 10.
Earlier this court has dealt with a similar FIR.
Yes, madam. Rejected earlier. All the other accused persons are released on bail, my lord. All the other accused persons are released on bail.
Where are those orders?
Those are regular bail, I think. 439. Those.
Yes, where are the similar orders?
So, my lord, kindly see page number 22. According to the official reports, the notes are genuine and not fake.
ভালকে শুনা নাই, কিবা প্ৰব্লেম হৈছে নেকি মাইক্ৰফোনটো?
see page number 25.
The petitioners here was traveling in that Wagoner.
Yes. No, this petitioner is not.
Petitioner is not.
He is not even FIR
They
name,
came
my
to the
lord.
picture after arrest of this Wagoner travelers.
The involvement of the petitioner came to light on the basis of the
Regarding fake
on the
note
basis of the statements of the co-accused.
My lord.
What is the stage of the investigation, Mr. Das?
Up to due to the IO has come, some materials have been collected against Nur Muhammad, Ziaur Khan. Ziaur Khan's house was raided. Some materials were seized, and one Muhammad Samad Ali. These three persons are allegedly involved in the racket.
What about the Nur Muhammad?
Nur Muhammad is here. He is also there.
He was involved.
See?
Nur Muhammad is one of them. They are
are
involved in
responding,
the.
They could not be arrested. That is why they are not.
He is involved in the.
My lord.
He's involved in what you said?
Racket regarding fake note currency, fake currency, printing of fake currency. Now, so far this seizure of 4,500 rupees currency note, those were sent to FSL, but FSL report says those are genuine currency, genuine Indian currency.
Also, the FSL reports have come.
Yes, yes.
And it is genuine.
That is there. It is genuine.
Then?
That is, no, but some materials have been seized, which are allegedly used in printing of.
No, but those 9 numbers of suspected denomination of 500,
Yes.
which was recovered,
It is
about
not fake.
4,500, that appears to be genuine.
Genuine.
Then let them appear.
Let's.
If that is the FSL report says that is genuine.
These three persons' name had clearly came out from the middle of
Correct. But this whole case
because-
started on that from after the
This is an
searching the
economic
vehicle,
offence.
correct?
After all, this is an economic offence. Involved in, and villagers
Correct,
also say
but-
they are involved in fake currency business.
Who says?
Villagers, seizure witnesses. Perhaps custodial intervention is necessary in this case. This is an economic offence. They are
4 persons.
Some incriminating materials have been during the course of investigation. Chemicals, papers, this type of.
The independent witnesses have implicated the petitioner,
In whose
villagers.
presence, some materials have been seized from the Ziaur Rahman's house.
Lordship, in the vehicle, 4 persons were present, Your Lordship. I am not there, Your Lordship. I am not owner, not driver.
Understood. It is
That is
later on.
Your Lordship, implicated me, Your Lordship. Your
No,
Lordship.
no, villagers, independent witnesses.
I have no knowledge, Your Lordship, about the any case, Your Lordship. Just, Your Lordship. And fake currency, 9 rupees, 9 notes, genuine, Your Lordship. That's Lordship also observed in Lordship's order, Your Lordship. Earlier, Your Lordship.
Which order? Page?
Page 29, Your Lordship. Third paragraph, Your Lordship. In other cases.
As regards his antecedent, what is the material available?
They say during the search operation, the seizure witnesses says that many people come to Ziaur Rahman's house. Ziaur?
I am not Ziaur.
No. I am not talking about you.
Something recovered from the house of Ziaur, not me.
Yes. They come, this Nur Muhammad, Ziaur and Zaman. They are, Nur Muhammad means this petitioner, Ziaur Khan and Damat Ali. They are actively involved in this fake currency business.
Something recovered from the house of Ziaur, not me.
Heard Mr. A.A.R. Karim, learned counsel for the petitioner. Stop. Also heard Mr. D. Das, learned APP for the state respondents. Stop.
There is shall cooperate the investigation.
This is an application under section 438 CRPC seeking pre-arrest bail in favor of the accused petitioner, i.e. Nur Muhammad alias Nur Muhammad, who is apprehending arrest in connection with Goripur PS case number 49 of 2024, registered under section 120 within bracket B, 420, 489 capital A, 489 capital C, 489 capital D of IPC, corresponding GR number 163/2024. Stop. The case of the prosecution in brief is that on 18/2/2024 an FIR was lodged alleging inter alia that on 17/2/2024, on specific information that some accused persons coming towards Goripur with suspected fake notes, a search operation was conducted wherein a white color Wagoner vehicle bearing registration number AS-16 G-9680, which was coming from Alamganj towards Dhubri, was stopped by signal. Stop. After searching the vehicle, police recovered 9 numbers of suspected denomination of rupees 500, totaling approximately rupees 4,500, and 1 bottle suspected chemical with 4 numbers mobile handset. Stop. Accordingly, the aforesaid items were seized and a case was registered. Stop. Mr. AAR Karim, Learned Counsel for the petitioner, submits that the petitioner was not travelling in the vehicle from which the aforesaid materials have been seized. Stop. He further submits that the petitioner is totally innocent and has no involvement in the offence alleged. Stop. Mr. D. Das, Learned APP, on the other hand, strongly opposes the prayer for anticipatory bail. Stop. He submits that it appears he submits that from the statements recorded, from the statements of the Caesar witnesses recorded under section 161 CRPC, it appears that the petitioner along with 2 other persons are actively involved in fake currency business. Stop. He further submits that the investigation has substantially progressed. Stop. I have heard the submissions made at the bar and have perused the materials available on record. Stop. It appears from the materials available in the case diary that the FSL report dated 6/3/2024 issued by the Directorate of Forensic Science, Kahilipara, indicates that the seized notes of denomination of rupees 500 are genuine Indian currency notes. Stop. It further appears that the petitioner was not travelling in the vehicle from which the bottle, suspected chemical and mobile handsets along with the aforesaid notes were seized. Stop. Next para. That being so, this court is of the considered view that the custodial interrogation of the petitioner may not be necessary for the ongoing investigation of the case. Stop. Accordingly, it is provided that the petitioner named above, in the event of his arrest in connection with the aforementioned case, shall be released on furnishing of bail bond of rupees 30,000 with one surety of like amount to the satisfaction of the arresting authority, subject of course to the following conditions. Number 1, 10 days appearance. 2, 3, return CD disposed of.
Obliged.
11 and 12.
This is the Bricklin.
The revenue department is realizing the royalty over and above of royalty by the forest department. The contention
This matter was heard for some time on the last occasion, I presume. Why was it kept today? Have you for the other side?
for his difficulty in
Yes. This is like, yeah, if I remember, there is no guide, there is no law, which provides collection of royalty, correct?
by the revenue department.
By the revenue department. Yes.
From my affidavit. I'll show for my affidavit.
Yes.
Earlier in the year 1984,
yes,
there was a government circular. Lord, may kindly take up my affidavit, our affidavit. This is filed on 29/11/23.
20. Your affidavit dated?
Dated 29/11/2023, filed in WPC 1259 of 15.
20 June?
No, 29th of November.
It will be page 88. Page 88.
That's page 88.
Yes.
The first circular, that is page 97. That is of the year 31st of March 1984.
Yes.
It talks about levying of royalty
over
government.
Yes.
This is the first point of time. Sir, in Annexure C, minor.
Now the first circular is at page?
Page 7. The 31st of March.
Please read.
Yes, ma'am. I am directed to say that it has come to the notice of the government that there has been haphazard growth of brick industry in the state, and many of the industrial units are using land from government PGR, VGR and government khas land without valid permission from the competent authority. The matter of realization of royalty and laying down terms and conditions for granting lease of land for manufacturing bricks been engaging attention of the government since a careful consideration of all the aspects have now decided to lay down a policy for granting lease for manufacturing bricks / tiles on government lands only for 3 years to private individuals, cooperative societies on realization of royalty at the rate of rupees 2.50 per cubic meter of brick earth on the following terms and conditions. So these are the conditions laid down.
Yes.
So this basically talks about the levying of royalty over government land. Thereafter, my lord, Annexure B.
Yes, page 101.
It says, a short one, I may read a minute. I am directed to say that it has been observed that some brick kilns have been set up on lands which are suitable for agricultural purpose. Considering the importance of agricultural land, the government have decided that no government land suitable for agricultural purpose will henceforth be allowed for setting up brick kilns. So this is protection of the agricultural land.
Ban on agricultural land.
Yes. And thereafter, the Annexure C, which is very important, 103.
10.
Page number 103.
Yes.
This is dated 26th of May 1986.
Yes.
I am directed to say that it has come to the notice of the government that many people have set up brick industry on their own patta land and on Sarkari and reserve land. Since bricklaying is an industry, apart from royalty at the rate of 2.50 per cubic meter, land revenue at the rate of 10 times of the highest rate of land in the village of Bhalbari should be assessed. So there are two things. One is royalty, the other is land revenue. All lands, including being enumerated here.
Sorry,
is for
I have not followed this.
But originally in the 1984 that circular, it says that government will levy
royalty on government land.
At the rate of so on government land. Now this one, this particular circular, 86, my lord, it again, my lord.
Yes, yes.
I am directed to say that it has come to the notice of the government that many people have set up brick industry on their own patta land.
Yes.
And on Sarkari and reserve land. Since bricklaying is an industry, apart from royalty at the rate of 2.5, they have also to be paid. They also have to pay the land revenue at the rate of this. So this is introduced in the for the first time.
So
in
apart from royalty, revenue.
Revenue. So both things they have to pay. This is introduced for the first time in 1986.
Right.
Thereafter, in 2001, this annexure D circular was issued.
Yes.
I am directed to say that government have reviewed the instructions issued earlier in connection with the establishment of bricklanes in the state. The revised instruction now issued shall supersede the earlier ones issued on so and so. Royalty. In addition to the land revenue we assessed and realized, as per section 25B of the Assam Land Revenue Reassessment Act, Rule 16 frame thereunder, royalty for the art used for the bricklaying shall be paid to the DC, SDO, Civil in the commencement of the season. A minimum rate of rupees 12,000 per year shall be paid as royalty for producing bricks up to 4 lakh number year. An additional amount of rupees 3,000 per year shall be paid for every subsequent 2 lakh units of bricks produced in a year.
This is under challenge in this petition.
Earlier round of litigation, there was a writ petition filed by this one, Bricklanes Association, where the petitioners were also members.
What happened to that?
There, in the final order was passed, that I have enclosed.
Page?
Annexure F, my lord.
Page.
Page, my lord. 109.
Yes.
The only grievance of the petitioner that demand of rupees 25,000 per annum by way of royalty is not justified. Respondents have filed an affidavit dated so and so. In the affidavit, respondents have stated that association of which the petitioner is a member has agreed to pay rupees 10,000 per year royalty instead of 25,000. So they have agreed to pay rupees 10,000.
In that case, the association is the petitioner.
Yes, and they themselves in their petition say that they are part of it, they are members.
This is individual or association?
No, they have come individually. 4 petitioners have come up to date. So, first leg of argument would be, if now they say that this 10,000 is not applicable in view of 2013 rules, that first rules, my lord, then they have to apply for modification of this order, my lord, even if they have a right, because this is a division bench order, my lord.
So no, this is not an order.
But then that consensus
This is
has been
withdrawal.
on the basis
What
of
is the
consensus.
order? What has been decided by the division bench?
Oh, there was consensus between the parties, the association and the respondents, and that on the basis of that consensus, the writ petition was closed.
No.
Parties
In
come-
the circumstances, learned counsel for the petitioner does not press this writ petition.
Yes.
And the same is accordingly dismissed as not pressed. Yes.
But the observations on the basis of which this writ petition was closed, that remains, my lord.
Because there
And
has been a
binding on them.
submission on behalf of the Additional Advocate General that the matter is being considered and hopefully it will be decided in favor of the petitioner and their association.
Yes, and that 10,000 has been, the impugn order says that 10,000 has been.
So that has been decided.
Yes.
From 25, it has been brought to 10,000. No, it has become 12,000 now. Correct? Huh? Where is it mentioned 10? This division bench order is 79/2010.
Yes. Subsequently, that.
And this particular 28 November 2001 was under challenge there. This particular notification 28/11/2001 was challenged before the division bench.
No, my lord. They were agreed by that 25,000.
Where is that?
That I do not have, my lord, but that was at that time it was decided to have 25,000. And
Yes.
the impugn order,
Yes.
page 76, 1259.
76
of the writ petition. This is under challenge.
76.
Yes.
76 is a part of the affidavit.
No, in WPC 1259, my lord.
Hmm?
In WPC 1259 of 15.
1259, yes.
Annexure P.
It is also part of the affidavit.
No, but-
This having revealed first time, we have amended the writ petition. After filing of the affidavit, this document came into record, so therefore we amended the writ petition by challenging this letter dated 5th June 2014 at 111.
Yes.
So this is impugned in the WPC 1259 at page 76.
Page 76
of the writ petition.
There is some 76.
Page 76.
In my affidavit also, I have an extra.
Just one second, I think I'm
affidavit.
getting it. No, 74. AO Ambohol. 76. There is some something wrong, maybe with the numbering. Can you ask your junior to just look into it? And also flag the amended writ petition. Mr. Borpujari, you are appearing in this matter. You are for the revenue. And you are appearing for?
Same revenue.
Okay. I don't think any clarification would be required. It's a revenue is represented. Mr. Kyle, for which matter are you waiting? Second file, itu file lock, itu ini na. Ini ada. Yes, 76.
Yes, and that is also included in my affidavit also.
Anyway, now I have 76.
This is under challenge. This notification, it says, in partial modification of government circular mentioned above, and in supersession of the all other previous circulars with respect to collection of royalty of bricklins, inform you that the government has decided to fix the royalty of bricklins of the state at the rate of 10,000 per year with effect from September 2010.
This is as per the
Yes.
that the concession given before the division bench.
And why we collect? Why the Department of Revenue collect the revenue, this royalty? That we have stated in our pleadings as well.
Just before that, what is the prayer in this amended writ petition?
That.
Where do I get the prayer? Yes. Page 17.
In the petition, they have challenged the notice. They were asked to get NOC from the Deputy Commissioner.
No,
and in
page
the
17 now, 5614, this is what they have challenged. And what is this 10 to 15?
10 to 15 I didn't get, madam.
That is also impugned, my lord.
Yes. What is that?
Look, 10 to 15 is the WT message. Based on that,
Which page I'll find this 10 to 15, Mr. Secretary? Page
72.
And 11 to 15?
WT message 10 to 25. On the basis of this WT message, this letter dated 11 to 2015 have been issued. WT message.
So your page 72 is the 11 to 15?
250.
Page 72.
72. So I'm challenging the WT as well as, my lord, this one, but I don't have the copy of the WT.
All right. So at the time of initial challenge, you did not have 5614.
Yes.
Subsequently, you got it. And therefore, you amended it.
Doing that also.
Prior to that, you had only challenged the WT message at page 72. So, but one query which has been, I think on the last occasion also, I probably has put it before you both. It appears that what you are showing is only administrative instructions. On what, can a royalty be levied without there being any provision in the statute? This is one issue which you will have to address.
True.
What is that position? That is what I think on the last occasion also probably I had asked this question, correct, Mr. Saikya? You have only shown me how you have been assessing because they are collecting royalty, therefore you have decided that no, some royalty must be paid. And you have been assessing since way back 84, correct? But that itself will not make it legal if today a challenge is put, because they have challenged the current levy. Alright, there was some concession, but there is no law decided by the division bench in this regard, isn't it?
Yes.
So that there is no decision as such. Now the issue has come up and it has to be decided whether this notification of 2014 levying 10,000 as royalty is valid or not valid. That is the issue to decide. Now, you have already indicated the reasons, correct, from your affidavit. But what about the legal aspect? Can you levy without there being a substantive provision, without there being any provision in the statute? Because this is ultimately a tax, correct?
And the circulars issued from time to time by the government.
Circulars are not statutory.
Circulars
are not statutory. They are administrative instruction. They are administrative, correct?
Holding the field, that at present they are holding the field.
That is why I am asking you this query repeatedly. That much this court has followed. That, but whether that now that itself is under challenge, so you will have to answer the query of the court that even when there is no provision in the statute, government can levy tax. You will have to show an authority to that effect.
In that case, my lord,
for that purpose only, I think last time also I had given time.
I actually came down late at that time when the matter was called upon.
All right, but
the aspect has to be answered,
ground matter taken in 2015 matter, so you will not be getting more time.
Yes, sir.
You look at Mr. Borpujari, that is the only aspect that needs to be addressed. The reasons you cannot improve the record. Whatever is there in your affidavit. Reasons are there, no problem. Now, whether that is, whether the government has that power or not.
Yes. So, what appears to me from the pleading, the term royalty, it has not been defined because in the pleading, in the affidavit, the authority says that they are applying the provisions of the Assam Land Reassessment Act 1936. 1936, my lord, lays down a procedure and a formula how to, my lord, calculate. And it speaks of, my lord, land revenue. In my respectful submission, my lord, the term royalty would mean and include, my lord, this revenue. Although perhaps not...
You are trying to now develop an argument that the royalty is a misnomer.
Maybe.
But
no.
Their affidavit doesn't say so.
Affidavit doesn't say so. Therefore, my lord, my...
You please, you see, you assist the court on the question that has been put. Because if you can show that is the only thing, if there is a please bring out those decisions.
Absolutely. So therefore, my lord, I would be, my lord, persuading this honorable court, if this honorable court please to frame an issue on that, whether my lord can...
No, why, what is the...
he can get the, my lord, inputs, my lord, from the department, because it appears, my lord, that royalty is nowhere defined.
There is no requirement for framing an issue in this writ petition. That is the only issue which falls for determination. The validity of the notification by which you are claiming royalty is put to challenge.
Yes.
Now you will have to show what is the backing of law.
Yes.
If you are charging royalty, you must show that the statute provides, and if the statute doesn't provide, you are competent to levy royalty.
Yes.
Royalty is otherwise a tax.
Yeah, tax.
Correct.
Yes.
There are also decisions to that effect. I am only, you see, these questions have come. At the end of the day, this court will have to answer these questions.
Absolutely.
Otherwise, the judgment will be a defective judgment.
Absolutely.
So you assess the court,
Absolutely.
you do some midnight oil burning. When can we have this?
19A of my writ petition. Amended writ petition. The letter dated
Just a minute, page
of the writ petition. Paragraph 19A.
14.
19A.
I think I have again, this is what is creating difficulty. Both the petitions are kept here. Okay. 14. Yes, 19A.
19A.
Yes.
That the petitioner states that the aforesaid letter dated 5th June 2014 issued by the government of Assam as
Source
well
of power.
Gotcha.
Correct. You want to emphasize that? Source of power. Yes, Mr. Borpujari. You'll have to, your affidavit doesn't indicate under what power you have levied that tax. This itself is, that is why I'm saying no issue is required to be framed. This itself is the issue.
Now, if my lord may be pleased to come to page 104. Page 104 of the affidavit.
104 I have seen.
Yes, 104, my lord, it speaks of royalty.
Correct. But what is 104? What is 104? It is a notification of the government of Assam.
Yes.
Correct. So that is why I am asking under what power? Where is it given? You will have to be backed by some statutory power if you are levying a tax.
That's true, my lord.
Have you followed what the query of the court?
Absolutely.
It's a small issue which is
it
involved.
Cannot be said even misnomer because of the very
No,
language.
this
in
court will not
notification.
accept an argument to that effect, that it is a misnomer. At the end of the day, what is levied, that will be seen. It is obviously a tax. How can that be a misnomer? Alright, when do you want it?
Next week, my lord. Next week, my lord.
Part, list again on?
So the, on 22nd, my lord.
22/5/2024. Just come up with on that day, only to that effect.
There is no source of power, my lord, then authority
And
does not have any jurisdiction to,
it
my
would
lord,
be
yes.
helpful if both sides can submit a small synopsis, maybe 1 or 2 page.
I'm so obliged, my lord. Obliged.
Mr. Saikia, you also have those authorities.
Yes, yes, I do.
You bring it. Correct. Because that, I think a decision also royalties are otherwise tax.
Tax, my lord,
And those schedule and everything is given under which. So you have
my
those
lord,
decisions.
that time royalty is, my lord, forest regulation, because the forest authority is where, my lord, the revenue authority have.
You see, in the forest there, the statute is providing.
Absolutely.
Correct.
Here,
Here, where is it?
Yes.
This is the question.
Correct. Absolutely.
You show me from your land regulation that it is permissible or whatever is applicable. That is the simple question.
So the affidavit is silent. That I must admit, my lord.
In the affidavit, you have brought out the reasons,
Yes.
but you have not brought out the power
Absolutely.
to which you can do it.
Absolutely.
Correct.
Absolutely.
All right.
I'm so obliged.
13 Lordship, I pray for 2 weeks' time to file my additional affidavit in opposition, Lordship. I have not been posted with the updated instructions, Lordship. It is a very old matter, Lordship, 2015 matter. Just this I want to bring on record, Lordship.
MS
R. Bora, Lordship.
R. Bora, Learned Counsel, for the respondent numbers 1 and 2,
Agriculture Department.
assures that the up-to-date instructions as sought to have been furnished in terms of the order dated 9/5/2024 passed earlier shall be furnished
Which shall
within
file my
2
additional
weeks from today. Stop. In view of the aforesaid assurance, list this matter. Prayer is allowed. List this matter after a date.
Highly obliged.
I have recorded your assurance, so do not fail.
Assuredly.
Yes, Ms. Kope.
My lord, it is relating to the central excise, lordship. Central excise 100% refund, and then there was the amended notifications which reduced the amount of exemption. So, during that time, during the pendency of the matters before the Supreme Court, come against that.
Demand notice.
We have taken refund more, should have taken less. Now, my lord,
You have?
I have taken more refund and taken at a lesser reduced rate at 56%, which they say. In terms of the Supreme Court, that time interim orders were there, so we had to get a little more refund we had taken. They have issued a demand notice. But now, Lordship, in 2020, the VVF judgment has come. VVF judgment has come, which he wants to say my matter is infractuous. I understand that this matters will be covered by VVF. But only one thing is that, Lordship, that old demand notice has to go. That cannot remain. The calculations in that demand notice will no more be now proper. The
issue petition in the basis of interim order passed by the Supreme Court 7/12/2015, and thereafter Lordship the final order was passed and upholding the notification. So the judgment will come into play.
In this matter before the Apex Court, the same issue was under challenge. The issue here is whether
we will get 100% exemption. Now it has decided that we will get the amended notification rates. Whichever industries get whatever percentage.
So then that will
follow.
That will follow, but only thing is that old demand notice may not stand then. That
automatically will be go away if we dispose this matter in terms of the Apex Court decision. The authorities will have to keep those in abeyance and proceed in accordance with this.
Proceed in accordance. This old notification. One more small
prayer. Can it be said that in terms of this decision of the Apex Court, those demand notices which are put to challenge has become infractions and
direction of the Honorable Supreme Court will follow.
In that line, can it be disposed?
Yes. And one more small prayer is that, Lordship, in these matters what is happening is, my learned friend also will agree, that after the Supreme Court judgments, petitioners are approaching the department saying that there is another provision in the Supreme Court judgment, a special rate. Because this matter was pending before this Honorable Court, so we did not file any special rate application. Now, 2020 the judgment has come. If we go with the special rate application, they will say it has become time barred.
All that this court is not doing anything. Well, Gopi, you make your let them. Why should we apprehend from now?
Their Lordship, only that's why I was telling that.
The operating part is from here. However, it is which is the operating part in this judgment? Paragraph 16. Can you read it?
Yes.
Have it?
Yes.
Please read it. 16. Paragraph 16. Can one of you read it?
Lordship, circumstances, the respective High Court take grave error in causing and setting aside the subsequent notification impugned before the respective High Courts on the ground that they are hit by the doctrine of promissory estoppel and they are retrospective and not retroactive. Consequently, all the appeals are allowed. The impugned judgment and order of the High Court passed by the respective High Courts, which are impugned in the present appeals, and setting aside the subsequent notification interest policy impugned in the respective writ petitions before the respective High Courts are hereby quashed and set aside. Consequently, the original writ petitions filed by the respective original writ petitions before the respective High Court challenging the respective subsequent notification interest policy stand dismissed. And the reasons stated herein above, the challenge to the respective subsequent notification interest policy impugned before the respective High Courts fails. However, it is clarified that the excise duty already refunded prior to the subsequent notification industry policies impugned before the respective High Courts, they are not to be reopened. However, it is further clarified.
This part you want?
Lordship, please see their prayer.
1 second. However, it is further clarified.
Lordship,
that the pending refund application shall be decided as per subsequent notification industrial policies which were impugned before the respective high courts, and they shall be decided in accordance with law and on merits and as per the subsequent notification before the so and so. No, what I'm trying to understand, Mr. K. In this writ petition, they have challenged those notifications which the Supreme Court said has failed. Correct?
Yes.
Now, in that view, it has gone. Yes. Ultimately, what will follow? This part?
This part will follow.
This part will follow, isn't
yes.
it? So, why I'm asking, because in that manner, I have to also say.
Now, Lordship, they will entitle to the exemption on the basis of subsequent notification, where rate has been fixed.
Let's do one thing. I'll come back at 2, since it's already 1 o'clock, and give the order at that time. Just what exactly needs to be directed, that part you both assess, because it's merely saying in view of the apex court may not be very appropriate. Maybe a specific direction in the line of this decision maybe has to be given. So
here my submission will be, they challenge the notification by which the demand was made. Their basic prayer was that there was at that time, relevant time, one interim order was valid. The Supreme Court says that they are entitled to half of the rate they are entitled to. Disputed that. In the meantime, Lordship, final order has come. So the interim order is not with the final order. So the final order will come into play. And as per that notification, they will be entitled to, if that is less, then they will be entitled to as per their entitlement.
Exactly, I am asking, in what line should I dispose of this case?
May I clarify?
To consider their claims in accordance with law?
Yes.
All right. This is item number 14 to
21.
Huh? Heard MS ML Gope, Learned Counsel for the petitioner. Stop. Also heard Mr. S.E. Kal, Learned.
Senior Standing Counsel.
Senior Standing Counsel.
CGST.
CGSC. Stop. As common question of law and facts arise in these group of writ petitions, and as such, is taken up together. Stop. It is submitted at bar that the issue involved in these writ petitions has already been adjudicated by the apex court in civil appeal numbers 2256-2263 of 2020. Stop. In the case of in the case of Union of India and another. What is this etc.etc?
It is reported in 2020.
It is reported?
Yes, sir.
In the reported case, what is the party name indicated, Mr. Kal?
Union of India versus VBF Limited.
Huh?
VBF Limited and
another. Union of India versus Messrs. VVF Limited. Reported in
2020.
2020?
Volume 20.
Volume 20?
SCC page 57.
SSC at page 57. So 2020, volume 20, 57.
Yes, 57.
Stop. In view of the aforesaid endorsement made by the learned counsels appearing for both parties, this court is of the considered view that the present writ petitions can be disposed of in terms of the decision of the apex court in Union of India versus VVF Limited Supra. Stop. Ordered accordingly.
Lordship, the demand notice has to
resultantly, after ordered accordingly, the
impugned demand notice at page 50, Lordship.
But that will be different in all the writ petitions.
Dates are different.
Dates are different. I'll write and give a slip.
I was thinking of making it a common, then I will not make it common. I'll pass it individually in all cases.
Or otherwise, Lordship, the direction given by the Supreme Court will follow in all the cases. Because it automatically that will go and the department can...
No, you see, if we are allowing this in this terms, then resultantly those demand notices will go. You agree to that, isn't it?
No, Lordship, there is no difference.
Exactly.
And Lordship, furthermore...
It will only make it clear. Resultantly, likhiba. Resultantly, the demand notice dated
36/2007.
36/2007 issued by the respondent number 3 stands set aside and quashed.
Department will proceed as per the direction of the Honorable
And the respondents are at liberty to proceed in accordance with law in terms of the aforesaid decision of the apex court.
That will.
Okay. Ms. Gope, just please ask your junior.
Make a list
Just
and
give us in a piece of paper.
dates and
Indicate the writ petition number, item number, writ petition number, and the date of the
demand notice.
demand notice. Itu common judgment or heri to kati dia. Kobo na lage common judgment. Baki sab ekei thakibo, ha? So, nai beleg. It will become easier, hoy নহলে.
My lord, item number 30, I have some difficulty in
Just
next
one
week.
second. Yes, item number
30, that may be kindly checked next week.
in item 30, as prayed for by MSML Gopal, learned counsel for the petitioner. You got that? Which is not opposed by Mr. S.A. Kal, learned senior standing counsel CGSC, list this matter again on.
After
Yes.
24th, any day.
After 3 weeks on a date to be fixed by the registry.
Much of
None appears for the petitioner when the matter is called. Stop. It appears from the last order dated 17/3/2021 that the learned counsel appearing on behalf of the petitioner sought time to obtain instructions in the matter. Stop. However, neither any instruction nor any representation is there today when the matter is called. Stop. In view, you want to say something,
Yes.
MS Fukan?
Preparing for AGCL.
In view of the non-representation, list this matter on Monday on so and so with the remark for dismissal. This is 22 to 26, na?
27.
Monday karo na Tuesday koile better hobe. MS Fukan, I'm changing the date to Tuesday. And because it's a hearing matter, if there is a representation, then probably the matter will have to be taken up for hearing.
Yes.
Alright?
Online.
Yes. This is?
I am for the respondent number 3 and 4.
None appears for the petitioner when the matter is called. Stop. In view of no representation on behalf of the petitioner, list this matter again on Tuesday, so and so date with remarks within quotes for dismissal.
Item 28.
None appears for the petitioner when the matter is called. List this matter on Thursday, date to debo. Thursday is holiday. Tuesday, bahi jabo. Tuesday with remarks for dismissal.
29.
Yes.
My lord, this is a small case, my lord, regarding ex gratia, my lord.
Regarding?
Ex gratia amount, my lord. The husband of the petitioner has been shot.
Can you speak a little loud?
My lord, the husband of the petitioner.
Yeah.
My lord, the husband of the petitioner has been shot, my lord, by the police, my lord. Therefore, my lord, now he is in bed. Husband of the petitioner, my lord. In an incident, my lord. Therefore, my lord.
Any guidelines in the field?
My lord, I have already annexed, my lord, page number 34.
Page number?
34, my lord. Relevant portion, my lord, page number 36.
Yes. Serial number 9?
No, my lord, serial number 8, my lord.
Serial number 8?
3.
Due to the firing of security forces. 3 lakhs?
3 lakhs, my lord.
Now, here are you disputing to the allegations that has been brought that the petitioner's husband was shot? Is it
It was
to firing of security forces?
Yes, firing was there, my lord, because there was a rioting in that place, my lord. Because my lord, in the masjid, prayer was wanted to offer the prayer in the room.
Sorry? I think maybe because the fan is here, I'm finding a little difficulty in hearing the 11 councils. Can you please speak a little loud?
Yes, my lord. Because, my lord, some people wanted to offer the prayer in front of the masjid, in front of the room, in front of the masjid, my lord. That is why there are some rioting, my lord. And in controlling the rioting, my lord, police, my lord, resorted to, my lord.
Whatever, but
Yes.
under this
Under this, my lord,
notification,
yes, my lord, under this he is entitled. my lord.
so if he is entitled, we shall dispose it with that direction.
Yes, my lord, that can be done, my lord.
All right? Is there any inquiry or anything, any report there? Nothing is there.
Nothing, my lord.
From where it is, from which, where one can see it?
SP has filed an affidavit, my lord.
See, because even if I have to dispose about in terms of this entitlement, there has to be something on record showing that the death has occurred due to firing of security forces. From where do I get that?
Paragraph 6. Paragraph 6, my lord.
Ms. Borman, you are following what this court is asking. Where is that?
The authorities are disputing regarding their presence or death, then court may not pass a similar order. But otherwise, it is or dead or they have their names have been appeared in the inquiry, then they will contact.
It is there.
That let me check that.
No inquiry could have been the next year.
Deputy Commissioner Hagadali Pare করেছে।
Here they are saying that he was part of that mob.
Yes.
In this is affidavit paragraph 7, it is mentioned that since so-and-so was a member of violent mob and while police resorted...
Whose affidavit?
Deputy Commissioner, respondent number 5.
No, but will that disentitle him from granting?
Don't think so much.
He will get it because what is required is that it has to be, the death has to be while firing, right?
Yes.
One line is there next to the...
One second.
Paragraph 4, my lord.
Paragraph?
Paragraph 7. Page 4, kindly.
Yes.
My lord. That Sri so-and-so
Was member of the violent mob.
Besides Sri so-and-so in violence, even though curfew was imposed from 1 p.m. to p.m. on 10/5/2019, and was also involved in mob,
Right, it is admitted that...
mob activities and administrative repeatedly
Okay,
requested
thank you,
to
Ms. Borman, for your assistance.
My lord,
You are Mr. F.A. Loskar. Heard Mr. F.A. Loskar, learned counsel for the petitioner. Stop. Also heard Mr.
M. Setia, madam.
M.
Setia.
Chetia, learned government advocate.
Yes, madam.
Government advocate for the state respondent, and you are there? And MS G. Hajorika, learned standing counsel, revenue. Stop. The case of the petitioner is that her husband, by way of the instant writ petition, the petitioner is claiming compensation ex gratia as per the Assam Disaster Management Manual 2015 and or Government of Assam notification dated 6/12/2014 in relation to her husband being killed due to the firing of the police on 10/5/2019 at Hailakandi. Stop. The brief facts of the case is that the husband of the petitioner was injured severely due to the firing of the police on 10/5/2019 at Hailakandi. Stop. While the husband of the petitioner was returning from the bank, the police fired as a result, 3 bullets has been passed over the body of the husband. He is not dead.
Not dead.
He's dead.
No, madam.
He is surviving.
Surviving, madam. In permanently.
For which he sustained severe injuries. Stop. In connection to the aforesaid incident, petitioner sought ex gratia grant in terms of the applicable guidelines, however, nothing was done. Stop. As such, this writ petition has been filed. Stop. Mr. F.A. Lockor, learned counsel for the petitioner, submits that in terms of the office notification dated 6/12/2014 under serial number 8, the petitioner is entitled for financial assistance if due to the firing of security forces, but one thing, it says if the permanently invalid person is innocent.
Yes.
Only then.
We
only
are
then.
disputing that, my lord. As per report of SP and DC office,
Because it appears that they are saying he is not innocent.
They are not innocent person.
Then he will not be entitled.
Right.
Because both the affidavits indicate that he is part of the mob.
Yes. In spite of
no, but you see, in that situation, when an application is made, then what is the duty of the government? Then an inquiry is made, correct? And dispose of the application. But that has not been done.
It is pending.
I think because that will not be correct, because admittedly a person has died. It is the stand of the government in their affidavits that he is part of the mob. Be that as even if that is correct, then the application filed by the petitioner ought to have been rejected in that terms, isn't it? So shall I dispose of this writ petition with a direction to the district commissioner
Instead of granting him and his entitlement,
That of course this court will now not do that, because initially I was of the impression that but this is there, it indicates only if he is innocent. So who should Deputy Commissioner की भी लिख रही है that the petitioner is entitled for financial assistance. Stop Korea. Mr. So and so, learned first learned government advocate submits that the financial assistance provided under the aforesaid notification dated 6/12/2014 is only in the event the person who has been the person who has become permanently invalid is innocent. Stop. He further draws the attention of the court to the affidavit in opposition filed on behalf of the respondent number 5 within bracket District Commissioner Hailakandi,
as well as my lord respondent number 4,
wherein at paragraph 7 it is clearly stated that the petitioner was involved in mob activities, and despite the administration's repeated request to disperse, the same was not done. Stop. He further draws the attention of this court to the affidavit in opposition filed by the respondent number 4 within bracket Superintendent of Police.
Yes, ma'am.
Superintendent of Police, wherein in paragraph 6 it has been clearly stated that the petitioner
was a member of the mob.
Aggressive mob. Stop. Heard the parties and perused the materials available on record. Stop. In order to appreciate the rival contentions made on behalf of the parties, the office notification dated 6/12/2014 is reproduced. 2014 is reproduced hereunder for ready reference. Stop. A perusal of the aforesaid page 34, Annexure 7. A perusal of the aforesaid notification indicates that in serial number 8 of the said notification, the governor of the government of Assam provided financial assistance of rupees 3 lakhs to persons who become permanently invalid due to the firing of security forces, subject to the condition that the person is innocent. Stop. In the next para. It appears from the affidavit in opposition filed by the respondent number 4 that the petitioner's husband was a member of the violent mob which was declared unlawful. Stop. Paragraph 6 of the aforesaid affidavit in opposition is reproduced hereunder for ready reference. It's a quote Koridiba, page 40. Further, it appears from the affidavit in opposition filed on behalf of respondent number 5 that that the petitioner's husband sustained injuries while the police was trying to control the situation. Stop. Paragraph 7 of the aforesaid affidavit in opposition is also reproduced hereunder for ready reference. Stop. Thus, it appears that there is a suspicion as regards the innocence of the petitioner's husband. Stop. The representations filed by the petitioner in respect of financial grant against the aforesaid notification is not addressed. Stop. In view of the above, this court is of the considered view that for the ends of justice, this writ petition can be disposed of with a direction to the writ petitioner to file a fresh claim before the district commissioner, Hailakandi, within bracket respondent number 5, and as and when such claim is made, respondent number 5 shall dispose the same in accordance with law. Stop. After causing due inquiry in the matter. This should suffice.
Yes, madam.
Not specifying the guideline or anything. In accordance with law, whatever is the applicable guidelines, correct?
Yes.
Yes,
Should I mention that he should file the claim within a particular period? Because I have not said anything.
Lordship may give direction to the authority to consider appending his representation.
Within a period of 2 months from the date of filing the claim. Last of all,
along with a copy of the order, madam.
Needless to clarify that the petitioner, while filing the claim before the concerned authority, would also furnish a copy of the certified copy of this court's order along with the copy of the writ petition. Stop.
It may be with my lord affidavit also, my lord, because.
All right. Returning. This matter, I had already.
List of the prepared a list of days of what happened.
I also made out a.
This is given by you.
Yes, madam.
No, I was trying to go through the file. Now there's a confusion. These persons were arrested on 20 or on 21st?
On 20, madam.
Are you sure?
Sure.
Because the forwarding report is of 21st. It does not indicate the date of arrest.
Yes.
From where have you said the date of arrest is on 20? Because you see, there are now admitted facts, Mr. Counsel, admitted facts as it appears on 19th. The incident occurred in which the victims were also injured, correct?
Yes.
Then thereafter an FIR was filed.
Yeah.
The FIR is of 29.
No. FIR is 20, madam.
20. Yes. 29, 20th September.
29, madam.
Correct. Now, on which date these persons were arrested? That
yes, madam.
What happened, madam? As
On
just 1 second. Then the anxiety that this court was having is on 19 these persons were injured. Now whether this person on 19 had gone to a doctor, what medical treatment they have taken, that is not coming. Okay. Now on 21st they were forwarded to the magistrate.
Yes.
And on 21st itself that report indicates that when they were admitted in the jail, they were given medical treatment at the jail.
No, before medical treatment was also given, my lord.
Correct. Before only I'm saying, at the time they were apprehended.
Yes, sir. My medical treatment was given. My lord.
That I have seen. It is here.
My lord. Put the page number 20 of the, my lord.
I have page 20.
Yes, my lord.
Further, IO has prayed for police custody of the accused persons for a period of 3 days for further investigation and to recover the stolen boat. So-and-so. OI also submitted that the accused persons being caught by public, they're seriously bitten by them. So this was on 19.
Yes, sir.
After going through the
19 night, my lord.
Correct. After going through the submission of IO and on perusal of CR and also from the physical appearance of accused persons, the treatment of the accused person is need of the hour, and accordingly prayer for so-and-so cannot be allowed. However, considering so-and-so rejected and with necessary treatment. Now there is on top you see it is given. Correct. Has arrested so-and-so and produced before me with memo and medical report. So medical, it indicates, it's a medical report, and there is another page from where it indicates that some treatment was given.
Thereafter, my lord, on 21, in the jail hospital.
No, I had seen in the morning, page 16. Page 16 is the forwarding, right?
Yes, ma'am.
16.
See, this is of 21st.
21st. My lord, one thing, my lord.
No, there is somewhere from where it appears that upon apprehending, medical treatment was given. I had seen that somewhere.
Yes, my lord.
Nowhere mentioned, my lord. Yeah.
I'm coming to you. 1 second. I'll come to you. I'm not going to pass any adverse orders without hearing you.
My lord, our affidavit, my lord.
In your affidavit?
28, my lord. Take up 5, my lord.
Correct. This is what I had read. Because Baxter state that Gopinath was admitted into the jail hospital at the time of admission into jail on 21st 9, 6:45, and provided medical facilities in jail hospital. During continuance of treatment at jail hospital, referred to civil so-and-so and then so-and-so.
Another affidavit is also there, my lord. By the, my lord, respondent number 6, my lord. Additional SP affidavit, my lord. Page 28, my lord.
Yes. Page 28.
Yes, my lord. Paragraph 5. This paragraph 5.
Got the accused from public and thereafter medically examined through the physician.
They are medically by the physician at Raniganj.
Your case is not custodial death as it normally would understand. Your case is that these two persons were already injured when they were caught, but for 2 days no treatment was given, and because of the negligence of the police authorities, despite the direction of the magistrate to give them medical treatment, they died. This is your case, and for that you want compensation, correct? Have I understood your case correctly? Now, the affidavits on behalf of the respondent number 6 and 7 indicates that first of all, these injuries were not caught and has not occurred in the custody of the police. They had already sustained the injuries, right? And from the affidavit, it appears that they have been given due treatment. Magistrate also have seen that bodily it is visible, accordingly directed. Thereafter also there is an explanation what they have done. After that, bail was granted, the petitioner was out on bail, and thereafter the petitioner died.
My lord, there is no record, my lord,
regarding
the affidavit.
have not
It
submitted
is said,
any record.
moreover, at the time of death,
Yes.
the said UTI Gopinath was not in judicial custody as he was already released on bail in the twilight of 22/9/2016 in Civil Dhusri Hospital.
I have not seen any record, my lord, in the week.
It is mentioned, and if I recollect,
May I please?
Before I started hearing this matter, this court had asked you if you want to file any reply against these affidavits. You chose not to.
May I place, my lord, my case, my lord?
Yes, you have already placed your case.
My lord, an FIR was lodged by 20.
You have already placed your case, Mr. FIR was lodged on 20th September.
20 September. My lord, when FIR was filed, they were caught by public. Public caught on, my lord, on 19/9. A whole night public, my lord, torture was caused upon them. And my lord, on 29/2016, my lord, an FIR was lost, along with, my lord, handing over the accused to the police. At the time of handing over before police, this FIR has been lost. As my lord, your lordship kindly see, since they were, my lord, physically injured, they, my lord, took the custody. The IO took the custody of 2 persons. My lord, and then and there.
Bar for taking custody if they are injured?
Yes, my lord. At that time,
is there a bar? Is there a legal prohibition? Because if they are suspected, obviously the IO has to take them into custody. But the question is whether any treatment has been provided or not, or the IO has ignored.
My lord, I am coming.
In this case, the affidavit indicates that treatment has been given.
My lord, I am coming, my lord. My lord, IO took custody of the 2 persons in injured condition. My lord, IO never thought about their treatment. And what happened, my lord?
What IO never thought?
My lord, IO should think about the matter. They are injured person. They should send to the my lord.
Mr. Counsel, you see, if you keep repeating your arguments, your case will not become better. You have already argued these things, and I have pointed out from the affidavit that the affidavit indicates that proper treatment has been given upon arrest. Now, you have not filed anything against that affidavit, no rebuttal, nothing. You had sufficient time. In fact, at the beginning of the hearing, this court made it also clear, right?
My lord,
and you said that you don't want to file. So now, how are you saying that treatment has not been given when the affidavit?
My lord, time may be given.
No, nothing doing.
There is no record on the.
I'm sorry. It looks like this is absolutely a frivolous petition.
My lord, on the other hand,
do not force this court to impose cost.
With all the.
No.
This concerned magistrate has passed after verifying the record.
Correct.
It is mentioned that medical treatment.
My lord, regarding bail, my lord, with all the respect, my lord.
Counsel, this court is giving a final warning. I'm going to pass the order now. Unnecessarily, do not.
My lord, I want to place my case.
You have already placed it. This is the second time you are placing it.
My lord, only one thing your lordship kindly consider.
Please do not repeat. You want to speak something, you want to address something other than what you have been submitting, you are welcome to.
My lord,
but please do not repeat your arguments.
Just, my lord, 2 points I will, my lord, place you for your lordship. One point, my lord. Police IO took the, my lord, accused on his own custody on 19th at about 3 p.m. 3 p.m. my lord.
Not on 19.
20 on 3 p.m. IO took the custody of. Your lordship kindly see FIR, my lord. Kindly see FIR page 13.
Please say what you want to say.
My lord, page 13, my lord. 29/2016, time 3 p.m. IO took the custody. But I never thought about their treatment. My lord, I am coming, my lord. With all respect, my lord. My lord, I am trying to establish the case, my lord. My lord, your lordship will pass necessary order. I have no question, my lord. My lord, IO what did, my lord? IO, without providing proper treatment, he took the two accused, my lord, in the police lockup for the night, whole night. No treatment was provided. My lord, on, my lord, 21, the 2 accused forwarded to the magistrate.
Mr. Counsel, you are simply repeating your argument. You are simply repeating your argument. Please take your
during,
seat now.
During this time, my lord, during no treatment was provided.
Mr. Counsel, please don't provoke the court for imposing cost. Otherwise, it appears it's a frivolous petition. I'm telling you. Likha. Heard Mr. A. Mannaf, Learned Counsel for the petitioners. Stop. Also heard Mr.
M. Chetia.
M. Chetia, Learned Counsel for the petitioners. Stop. Respondents. Stop. By way of the instant writ petition, the writ petitioner is seeking appropriate compensation in favor of the petitioners, the next kith and kin of the victim, Gopinath. It is you are for only one of the victim.
My lord, one of the
one victim,
Gopinath,
who was the bread earner of the family, who died during judicial custody for the negligent act of jail superintendent, District Jail, Dhubri, Assam. Stop. The brief facts of the case is that on 29/2016, one FIR was lodged by Nipun Nath alleging that on the night of 18/9/16 at about on 18/9/16, unknown miscreants entered into the house of the informant and stolen away two numbers of gas cylinder from his house. Stop. On 19/9/2016, informant came to know from the local public that one Gopinath, within bracket, how is he related to the petitioner?
My lord, petitioner number 1 is the wife, my lord.
Husband of petitioner number 1.
Daughter.
And another Shahadev Nath. Stolen away the gas cylinder from the house of the informant. Stop. Accordingly, the informant, with the help of local public at Pokrajar, apprehended the two accused persons and they were also beaten by the public, and after beating them they were handed over to the jurisdictional police station, wherein the said two accused persons also confessed to their involvement. Stop. Mr. A. Mannaf, Learned Counsel for the petitioner, submits that on 19/9/2016, when the police personnel had picked up the two victims, the victims were badly injured.
On 20,
my lord.
Sorry, sir. On 20/9. Sorry. On 29/16, the victims were badly injured, and as such, it was incumbent on the police personnel to provide necessary medical treatment to the victims. Stop. He further submits that upon the said two accused / victim persons being produced before the Subdivisional Judicial Magistrate on 21/9/2016, the Subdivisional Judicial Magistrate, upon seeing the accused persons, directed the police personnel to provide necessary medical treatment to the said two accused persons. Stop. He further submits that despite of the aforesaid direction of the subdivisional magistrate, no adequate medical treatment has been provided to the accused persons, for which both of them died, for which Gopinath I, husband of the petitioner number 1,
father of petition number 2,
died. Stop. Next para. Mr. So-and-so, learned government advocate, on the other hand, that necessary medical treatment were provided by the police authorities after apprehending the accused stroke husband of the petitioner number 1, and upon providing medical treatment was forwarded to the Honorable Court of SDGM, Bilasipara, on the next day, i.e. on 21/9/2016. Stop. He further submits that on 21/9/2016 at about 6:45 p.m. when the husband of the petitioner number 1 was admitted into the jail, he was admitted into the jail hospital, wherein medical facilities was also provided. Stop. He accordingly submits that this is not a case of negligence of the police authorities, for which the police authorities can be held accountable for the death of the husband of the petitioner number 1. Stop. I have heard the parties and perused the materials available on record. Stop. It appears that the husband of the petitioner number 1 was apprehended from the local public and thereafter medically examined through the physician of Raniganj BPAC, namely Dr. Ratul Das. And after completion of the medical examination, the husband of the petitioner number 1 along with the other accused person were arrested and forwarded to the Honorable Court of SDGM M Bilasipara on the next day, i.e. on 21/9/2016. Stop. The forwarding report dated 21/9/2016 indicates
Order of the magistrate.
Yes, yes.
Page 21.
It further appears that on 21/9/2016, when the husband of the petitioner number 1 and the other co-accused were produced before the learned magistrate, a copy of the forwarding report, arrest memo, medical report, etc. were also submitted. Stop. It further appears that the aforesaid said medical report submitted was seen by the learned SDGM.
Yes.
Stop. upon going through the CR means what? Case records.
Case records.
Upon perusing the case records and also from the physical appearance of the accused persons, comma, the SDGM directed the jail superintendent to provide the accused persons with necessary treatment. Stop. It further appears that pursuant to the said order of the CDGM, comma, at the time of admission of the husband of the petitioner number 1 into jail on 21/9/2016 at about 6:45, comma, the husband of the petitioner number 1 was admitted into jail hospital, wherein medical facilities were provided to him. Stop. It further appears from the affidavit in opposition filed on behalf of respondent number 7 that during the continuance of treatment at jail hospital, comma, the husband of the petitioner number 1 was shifted to civil hospital Dhupri as per the reference made by the jail doctor on 22/9/2018. Stop. It further appears that the husband of the petitioner number 1 was released on bail on the twilight of 22/9/16 as per the release order of the Honorable Court while he was undergoing treatment in the Dhubri Civil Hospital, Dhubri. Stop. Paragraph 5 of the said affidavit in opposition, against which no rejoinder has been filed, is reproduced hereunder for ready reference. Paragraph 5, continuing page 36 of Pabo. Paragraph 5, 7 and 8 corridor. From the aforesaid averments made in the said affidavit in opposition, it appears that necessary medical treatments at all stages have been